Alright, most of you I've been learning to meet when I can. If you don't know me yet, my name is Garrett Brandt. I am the new Director of Risk Management as of December. I took over for the infamous Hank Bronstein, so that now tells you my role. But, thank you, I heard one person talk. Thank you. It's really been an exciting 3 months getting up to speed, learning as much as I can about you all, meeting you all, and hopefully giving you constructive ways of making your contracts and your transactions go smoothly while still towing the line to keep us out of the site trek as much as we can. That's obviously my main job. And I really enjoyed this, and I'm really honored to be up here this morning. I feel like the low man on the totem pole compared to these two. Most of you probably know Bo Blackburn. I swear I wasn't going to butcher your name, but here I will admit it. Bo is our outside litigation counsel. He is a shareholder with Almanza, Blackburn, Dickey, and Mitchell LLP in Austin, which he formed in 2010. He's also, he has his law degree from Texas Tech from 1998, where he graduated cum laude. He is the lawyer appointed member from the State Bar for the lawyer member TREC since 2011, so he is a part of our TREC committee. And give Bo a big round. He does a good job.
I'm not sure if this is live.
There we go.
Thank you for having me. It's always good to get out of the office and come spend time with you folks. So thank you for having me.
And then next to Bo, we have Avis Wukash. Did I say it right? Wukash. She is a part owner of the Keller Williams in Round Rock and Georgetown area. In 2011, she was appointed by the governor to be chair of TREC as a broker member, and she was recently reappointed and has a term as chairperson until 2019. She was also named Realtor of the Year in 2011. She's a past chairman of TAR, and her whole family, I understand it, has been realtors. Started with your dad for more than 50 years, and some siblings and a husband. I got all that right? So she probably knows a couple things about real estate and TREC enforcement. So we're going to run this kind of a little informal. I have some broad topics that I wanted to bring to their attention and see what they have to tell us, and we can just kind of get into that. So first, if each of you could tell us your role with TREC and kind of your vision of what you see you want TREC to be doing and how you see it involved in these folks' lives.
Well, thanks, Garrett. And I am not an attorney, so don't get confused. I'm one of you guys. And so when I tell you something, it would be best practices, not the law, right? So my role at the Real Estate Commission is chairman of the commission. As you know or remember from taking your exam and taking your early classes, there's 9 members on the Real Estate Commission appointed by the governor. And the chairman is also appointed by the governor. So there you go. And it's not this governor, it's the one before that made that appointment. And my vision for the Real Estate Commission, I've been on the commission for a while now, and we've done many things that I wanted us to do, as any good Keller Williams person would have, I had goals and dreams, and they were written down for the commission as well as our business, and we've done a lot of that. Had to do with making brokers more cognizant of the responsibility that they have as a broker, and creating rules that are simpler to understand and easier to enforce. That's the hardest part. And of course, making education mean a little more something. Now, you may or may not like that. It's gotten harder to get a license. It's gotten harder and will continue to get harder to become an instructor. I believe that people who instruct license holders should actually be competent and aware of the materials and know that what they're teaching is correct. So I'd like to stay on that path, and that's my role and my vision.
Again, I'm Bo Blackburn. First of all, let me start off by saying that Avis is not a lawyer. However, if she tells you something, you should listen to her, not me. I can't tell you how many times, I'm not joking, you don't know this, but I can't tell you how many times I get a call from an agent or a broker and they ask me a question, and they don't tell me before they ask me the question that they've already called you And then they say, well, Avis said this, and I said, well, do whatever Avis said. So we're very lucky to have Avis with us today. We're very lucky to have her with us today. She's incredibly knowledgeable about not just your practice, but the law as well. So thank you for being here. I am on what's called the Broker Lawyer Committee with TREC. We're the committee that is responsible for drafting and updating the forms that you are required to use when you conduct real estate business here in the state of Texas. I've been on that committee for 4 or 5 years now. I was appointed by the state bar president, I guess 5 years ago. That's really the only role I had within TREC. I also have probably a little bit of a unique perspective that not only am I a member of the Broker Lawyer Committee, I still represent brokers and agents when there are complaints filed against them at TREC. So I have what I think is a little bit of a unique perspective on TREC. So what is my vision? Avis hit on a couple of things. One of the first word that pops into my mind is communication. There needs to be better communication flowing from TREC to the agent population. One of the things that I think is a huge step in that direction, I would be very curious to take a quick survey, but I'm not going to. There's a new, TREC just went live with their new website, which I think is much better. It's going to help a lot with what I want to see is better communication flowing from TREC. But TREC can only do so much with better communication. For those of you who are married, you probably heard this, it takes two to communicate. I see at least one of you smiling at that. You guys have to actively engage in that process. You have to actually go to the website. You have to actually read some of the stuff that's coming from TREC for there to be effective communication. One of the things that happened in the last couple of months was some new regulations in terms of licensing and information. And I can't tell you how many calls I got from brokers saying, why didn't TREC tell us about this? Why didn't TREC tell us about this? What's your reaction to that?
I have a great reaction to that, and that is, nothing happens quickly. You know, in your business, if you decide tomorrow you want to change what you're doing, you just do it. At the commission, everything takes an enormous amount of time.
And there is communication.
And there's plenty of communication. We draft a rule, we propose it. There's time, sometimes 6-8 months time to make comments before we actually take final action.
Exactly. So there has to be, for TREC for me to just sit up here and say TREC needs to do a better job of communicating is really only half the story. You have to engage and be part of that communication. So that's probably for me the biggest thing I would like to see is TREC and you guys doing a better job of communicating with each other.
Thank you. So with you being on the broker lawyer committee and also representing brokers, you might want to take the first stab at this, but what do you think are the top, I say top 5, but what are the top infractions that you see agents get brought before TREC over and over again? Things that we can impart here, and hopefully they can learn from other people's mistakes.
The two big ones, well, I shouldn't say two big ones. The ones that pop to mind first are, I'm going to kind of combine together. I think Avis may have these broken out separately, but breach of fiduciary duty and competency are the ones that we see over and over and over again. And what I mean by that is there's an allegation that the agent either put their own interest first or didn't put the interest of their fiduciary first. They did something that went against their client's interest. They went outside their area of competency to do something. For instance, if you've never ever done a commercial listing, and you decided to do a commercial listing and you did nothing to prepare yourself to take on that commercial listing, that can lead to complaints. That's kind of the big one is breach of fiduciary duty and competency. Then I would say followed quickly by advertising. Advertising is a big one that we see over and over again. And at least for me, this wasn't intended to be, I'm going to teach you how to do these things right. I just wanted to draw your attention a little bit to the areas that we see over and over again. So advertising is a big one. And then, how can I forget this one? Property management. Those are the ones that I think I see over and over again. I think Avis maybe wanted to expand on a few of those.
Yeah, but
Yeah, actually, though I have known each other a long time, everything he says I would agree with. Also, I have just a little bit of, get a little more in the weeds on a couple of these subject matters. Breach of fiduciary duty is the number one complaint against the license holder at the commission. And things like failure to deliver documents timely. We had somebody we fined $1,000 last month because their buyer needed to back out of the contract during the time period in the third-party addendum because their lender did not get the loan done, and the agent failed to deliver the notice to the other side, and the buyer lost their earnest money and could have been sued by the seller. They were not sued, but the buyer brought action against the license holder. And that's just, to me, that's sloppy work. That's really sloppy work, and yet it's a breach of fiduciary duty and is actionable at the commission. Another one that we find somebody, actually, there were several infractions on this person, and their license was terminated because of how many things they had done wrong, but the straw that broke the camel's back, if you will, was offering a rebate on a website to a consumer for buying from them. Now, there's nothing wrong with offering a rebate as long as you're clear on what you have to do to get it, as long as your broker knows that you're offering it and they agree to that, and that you actually give the rebate when all those things have been met. So everything that I said, that person didn't do. They didn't have their criteria on the website, they didn't have their broker's permission to give it, and then they didn't pay it. So ultimately, they were fined and their license was terminated. But this was, if you will, at the commission, generally, infractions are, I would say, piled on. Unless it's incredibly egregious, your license will not be taken away on the first offense. And this was not hers. So those were a couple things. I think I can cover the others. I wanted to say that are both sloppy work and breach of fiduciary duty when I talk about another one of these. Property management and leasing, when you put those two together, that's really way above breach of fiduciary duty. Complaints. The thing that concerns me, you guys know what property management is, and you probably think you aren't doing that. You may even have a policy against you doing that. I don't know. You accidentally can get into property management when you do leasing. If after it's all said and done, the tenant or the owner call you up and say, could you get us somebody to fix the toilet? Because the seller owner lives in California, they don't have any money, and you do that, you pay them, and then expect to get your money back. You've suddenly gone into a property management relationship. You could be held liable for all that and for the work of the plumber that you sent over there. That stuff happens. Be careful. Just generally, the bad things are property management. I call it theft by property management. You probably wouldn't do that, where you take all the money and never pay anything. Yeah. We've had that happen. One that I see that may not affect your people at all is what I call renewals and amnesia. There's a question when you renew your license.
Yes.
Okay. There's a question when you renew your license. It's something like, you done anything wrong lately? I think it says you committed a felony maybe, but I see it as you done anything wrong lately. And amazingly, people who've just had their third felony, DWI, studied no.
Wasn't me?
Wasn't me. Somebody looked like me. Amnesia is the only thing I can call it, because let me just say, remember the fingerprinting? We really do, like, go send that back through the FBI database, and it's going to be just like your children. Don't lie to me. Don't do something wrong and then lie to me. Tell me the truth. So if you did something wrong, say yes and explain it. Don't say no and then expect us to buy your amnesia.
I just wanted to thank you right now publicly for getting that through. I made so much money off that job. I almost finished that command in the back of my house with that one
Surely
check.
you've got something else going there.
I had at least 100 clients call me and say, I forgot to put this conviction on my application, and now they're not putting it through.
Are you?
So thank you.
You're welcome. It hasn't gone away. just keep at it, baby. I think we're going to talk about advertising later, but advertising is certainly a big issue. And anything that tends, the law says if you tend to mislead, tend to mislead. I can make almost anything intending to mislead, just say that. And then there's some other things that people do that are sort of amazing that they get away with, like bribery. And anyway, that's good.
If I could just ask one thing about the property management. Now, in Keller Williams, we have a policy that we don't want you to do property management unless you can give permission and you have your broker's license. But getting the broker level license, that's also a track level requirement, right? This isn't something that we're
Well,
just doing.
It's not a requirement. If your broker is willing to take the responsibility for your property, because it's the broker's property management business. It's
Okay.
not the sales agents, unless it's their personal property
Their
that they
personal
own.
property, right?
Yeah.
Okay.
So, and we go a step further. I'm not on the commission now. I'm the broker for 2 market centers in north of Boston. And our policy is not only you have to get your broker's license, but you create an entity and do your management in the entity name. So it's one step beyond just becoming a broker. Because I want a little bit further arm's length away from that.
I don't know the answer to this, but I'm going to ask you, do you require any type of software to be utilized to manage the property management?
I do know. And if you were my E&O attorney, and that might happen someday, I would ask you if you think that's carrying it too far in me managing what they're doing and gives me some liability for what they're doing.
Probably.
Okay.
Probably does. And I'm just curious what you do.
No, we have an affidavit that our attorney drew that all the landlords have to sign, saying they understand that if it were, it would be that Bo has a business where he does property management and he does all his sales under us, and the two aren't the same. It's much more larger than that. That's trying to put this wall up between us on property management. Very
good. What do you see as a couple pet peeves that you have that agents and transactions continually make? They're borderline track violations or just things that you say are sloppy. I like the word sloppy. To me, it's just inattentiveness to their thing. What are your big pet peeves that you find?
I'm happy to go first. The one that I see, and I don't know if this is a pet peeve, it's just something that I see getting people in trouble over and over and over again, is the taking on obligations and duties that they don't need to, number one, and number two, should not be taking on. When I teach my CEs and go talk about risk management, one of the biggest things I want to get across is stay in your lane. Henry always says stay in your lane. It's great advice. Stay in your lane and make sure you keep the right hat on. If you're a buyer's agent, make sure you have your buyer's agent hat on. Don't take your buyer's agent hat off and put on your inspector hat. Don't take your buyer's agent hat off and put on the engineer hat. Remember, I've heard somebody say, be the tour guide and not the explorer. It's your job to point out things that are going on in the transaction, and it's your client's job to be the decision maker. What I've seen change over the last, almost 20 years. My wife pointed out some white hair coming in this weekend, and I think I've earned it, honestly. But over the last 20 years, what I've really seen, a lot of things. One of which is the buyers, especially the buyers, are becoming less engaged with the process. They are a passenger. It used to be a front seat passenger. Now they're a back seat passenger, and the agent is making almost all of the decisions for the buyer. And when you do that, when there's a decision that turns out to be problematic, then you become legally liable and responsible because you were the one that made the decision for the buyer. If you be a good tour guide and point out what the issues are, and then they make an informed decision, then they live with that problem. And that's the thing that I probably would say I've seen over the years change more and more and more, is buyers, and especially in this market, buyers are less engaged than they ever have been before.
Can I elaborate on a couple things that I thought of when you were talking about what you said? 3 things, and it may not affect you, might, in New Braunfels. Rollback tax issues. If you're selling a property that might have a rollback tax issue, you should not be the one to tell them what your appraisal district is going to do. You should refer them to the appraisal district. what school district is the house in. I don't know what happens here, but in Williamson County from time to time the schools change that. And you don't want to guarantee a school district to a consumer. And the other one that we're...
Can we role play that second? Will you be the buyer?
Okay.
The buyer's agent.
Okay. Hey, we have to be in the, I don't know the schools here, Westlake School District. And my children have to go there, no matter what. Can you guarantee us that we're going to buy a house in that school district?
Well, here's what we can do. I think this house is in the district, but what I do know is that these things change pretty frequently. So I'm going to refer you to the place where you can get that question answered with 100% certainty. And then I go back to my car after, or go back to my office after we have that conversation, and I send you an email that says, I know it's important to you to have a certain school district. Here's where you can go and get that information found out 100% accurately, and I want you to reply to this email so I know that you received it.
That was good.
Thank you.
That would work also with rollback taxes.
It does.
And the next one, which is mineral estate.
It does.
And your license doesn't give you the authority to establish a mineral estate or know what it is. Somebody wants to convey minerals on a piece of property. Okay, sorry. Something else.
No, that's good. One thing that I see in this role is what I would just consider sort of lazy drafting, especially when it comes to repair amendments and the like. It's sort of the, hey, we're just going to attach a couple pages of the inspection report. Well, the inspection report may or may not give definitive directions as to what needs to be done, and it could include things that the buyer didn't really want to be done. But when we get into words like, hey, check the AC, make sure it's functioning, the seller's going to walk out and go, yeah, it's on, and now their job is done, when the buyer really wants it to be inspected and service is needed and the whole 9 yards. So the sort of sloppy drafting is going to come back and harm you later when the buyer doesn't get the results that they want, and suddenly the seller says, well, we're at the closing table, where are you? So you need to be really aware of what you're obligating your seller or your buyer to want to do. This is kind of a forward, well, we have the advertising next. Let's talk about advertising, especially as it comes to group and team names. And this gets into my last question for you, and that is, what do you see coming next from Trek that they're going to need to be aware of and I'm going to have to help them
With advertising?
advertising, and just even beyond that, if you know something else that's coming up. I'm not trying to pick up the spot too much, but...
This is probably mine.
Okay.
We've been working 16 months on an upgrade to the advertising rules. Some of the advertising rules go back 50 years without change. And we haven't been successful in getting anything done that met the criteria that the commission laid before the committee or before some other people that were working on it for us. And those two criteria were create a rule that for the consumer, so the consumer can find the person in charge, and the license holder can understand the rule easily.
Okay.
You can't imagine how hard that was. 16 months, 7 drafts, and now there's a bill before the legislature. So the Texas Association of Realtors felt like that the commission was never going to come up with an answer, even though they were the ones keeping us from creating an answer. Can you tell I have some emotion about this? Anyway, they've proposed a bill, and it is currently in the legislature. If it passes, what will change really for us is virtually nothing. What you have to have, what you will have to have before the rule, as the rule is now, as the statute will be, as the statute is now, even though with this change, you will still have to have Keller Williams Realty on everything. At least half the size of the largest other contact information that's on the media, whatever it is. So that's not going to change, I don't think. Now, anything's up for grabs because it's in the hands of the legislature. Here's why I fear that more than anything that you can imagine. Let me explain it like this. How many of you know when you take a listing whether or not it complies with Chapter 766 of the Health and Safety Code? Do you know that question on the seller disclosure? And you know that there's a real good reason that happened. There was a death in San Antonio of a senator. The senator that was remaining took that bill, had some people write something to put in the seller disclosure, when in fact what they wanted was something like this. Y'all got a smoke detector? Yes or no? Do it work? Yes or no? And what we got out of the Texas legislature in its infinite wisdom was, does your house comply with Chapter 766 of the Health and Safety Code? Which nobody knows that. You can't know that. I can tell you what that means if you want to, but you probably don't. So that's why I fear our advertising in the hands of those people that we elected, who don't have any idea what we do. So I'm fearful of that.
Well said.
And so until it is over and done with in May and the governor signs or doesn't sign it, I can't really speak to it. I can tell you that what is not in there are any specific statutory changes to anything that would affect teams. I can talk just a little bit about what we have talked about as a proposal for team rules. And you know, Keller Williams, we're a whole lot of the problem for the rest of the world. And too bad. Anyway, I've worked hard to make it better for us. I'm not sure that it's necessarily working, but the proposal that looks like it might get some traction, may not happen until the summer, is for there to be a separate rule for teams, for there to be a separate place to register the name of the team, not as a DBA for the broker, but as a team name that is portable if you change from one company to another fairly easily. A form to be created for you to register that name. And this will perhaps upset you. Too bad. The only names that are currently going to be considered acceptable, unless something changes, are team and group. So all of those names that you have, like realty and homes and properties and farm and ranch and I don't know, whatever else you have for your team, you can't use them. You're not supposed to use them now. They're not acceptable now. Don't think they'll be acceptable when the new rule goes into effect. So that's kind of, in broad generality, what's going on. What has happened, Garrett and Bo may or may not know this, is when we began the process of working on the advertising rule, enforcement sort of put a moratorium on necessarily going out and seeking advertising violations. If you have a complaint filed against you on another matter, they will pick up your advertising violation and do something about it, but they're not out seeking it. When the statute passes and the rules pass it, Katie, bar the door, here it comes, I'm just saying. The statute as it's currently drafted has I think a 12, it's a year, a little more than a year before it goes into effect, so we have a little time to come into compliance with it. That's where we are. I will tell you that last month there was a complaint filed, and a team name with a Keller Williams office in Austin was not properly filed, and the team was fined $500 and the broker was fined $2,500. So, and it was a first offense for the team, not a first offense for the broker, and it wasn't me. So, although that could happen, because that's what I do.
As we get more and more teams, as we're growing businesses, the potential for somebody going out and just doing it or slipping past somehow increases. And so we need you all to take a little ownership with when these rules come out, to look at it and help us help keep you in compliance too. Well, that's what I had for our panel this morning. Boy, I'm honored, Avis and Bo, that you were here. I really appreciate you coming down from Austin and North Boston.
All right, this is cool. This is my first time in the theater here. This is the original. This is like, I mean, Palladium doesn't have it, right? This is cool. One thing we need is some popcorn and some mimosas. We didn't tell you we had mimosas in the back. Boys got them, you know. Okay, we'll sneak you one up here if you want. Real quickly, there's a couple slides I think are critical that we at least let you know that we've updated for the year we do every time. We have some really cool new technology stuff we're going to share with you later. But to tell you right now, we're going to look at the stats. They will be available as of this afternoon or by tomorrow. We will have them up on the intranet and available for you to use in your marketing material for listing presentations, buyer presentations, And if you just want to show, grandma or your spouse that you really are part of a company, you're doing a great job. So, real quickly, we wanted to talk real quick the top 10 brands in San Antonio. This was actually provided by the Broker Metrics report. This comes from we run these reports from the local multiple listing service. These are the tall tale signs of who the marketplace is, who's doing what. We don't make these numbers up. The statistics are what the stats are. The numbers are the numbers. We do not manipulate them, and this is what they are. When you talk about top 10 brands, we are over double the size of the next biggest competitor in the marketplace. That's every single RE/MAX office out there against our three main companies at Keller Williams. So when you see the size, just by sheer numbers, we're over $3 billion in the multiple listing service as of 2016. That was in 1 year, over $3 billion in sales. And that's all due to y'all. As you can see, we did put these stats of the other companies. It got kind of hard when the graph got really small, but we did the best we could to put their names up there. And we go to the next slide, but you can use that to your advantage. I do believe, go one more back. You know what that tells me more than anything else? That tells me that one out of every 5 transactions taking place in real estate has one of you involved in it. That's pretty awesome. I mean, that's saying a lot that 1 every 5, and I think by next year it'll be 1 every 4 transactions should be with a Keller Williams agent involved. And that says a lot about you. You're number 1, and which makes all of us a better company. Go to the next slide. Real quickly, the next slide. Next slide. Oh, perfect. Okay, top 10 brands, and this is by volume where we were in the marketplace, and from 15 to 16, we did increase. It didn't show our numbers. I think we went up by, I think, 12%. It's not on that slide. But look at some of the other offices. What happened? Do you see a trend? And we believe a lot of the training, we believe the coaching, the mentorship, a lot of the resources the company has, and your hunger to take your business to the next level with what's going on in the marketplace proves to us that we believe that Keller Williams is a place of choice that you have. You've got options, but we are continuing to grow. In spite of all the other large offices, we're still growing in the marketplace. Next slide. This is the top. Now, then we broke up the top 10 brokerages, not by franchises, but by brokerages. So we just took what's the largest brokerages in the city, and this is what we came up with. And we're going to show new brokerage stats in just a second. Let Stephanie show those. The Heritage Market Center, and then the next one right beside KW Heritage is KW Legacy. It's not, for some reason, it didn't show up on that graph. But you'll see between City View. City View is right beside Keller Williams Heritage. The entire Coldwell Banker brokerage is number 3. And then Legacy is, I think, I think Phyllis Browning showed 3.9%. And then KW Legacy is at 3.5%. This is breaking up each one of the graphs. Sorry, we worked really hard on this, and for some reason the formatting didn't come out on the screen very well, but we will make sure that the names are fixed on that. But once again, Keller Williams Heritage, we're going for almost 10% market share by next year. That means just this office, 10% of the entire market. That says a lot. 1 out of 10, we want 1 out of every 10 transactions of a Keller Williams Heritage agent to represent our clients in the marketplace. Pretty impressive. Moving forward, the 5 biggest companies in the luxury market. We thought this was pretty good. Only one mistake we've got to make on there, and I know it for a fact, which will be changed. That 1 million is supposed to be 500,000. So on the luxury market above 500,000, we have 22% market share. Did people know? I mean, did you even think that was possible? Most people say there's no way that y'all have that much market share. No, it's true. The reason I think the problem with where we're at is we're not promoting and marketing that well enough to the marketplace. And we always say, well, it might be just a 2 or 3 boutique real estate companies. That's not true. By sheer size, we have more luxury listings and sales, undisputed, in the city of San Antonio and the surrounding cities such as New Braunfels, Boerne, Fredericksburg, Kerrville, and so forth. No question. 5 companies in luxury. Yeah, thank you for just making the change right now. That's awesome. Thank you. That is good tech, right? All right, moving forward. What you're surprising. Remax, is that a national brand? Is that a national brand? Do they have a big balloon? I was at the racetrack the other day, and we were at Austin. What's that? The big the Speedway. And Remax is huge. I don't know how many millions and millions of dollars they spent in marketing. 5% of the luxury market, and they're spending millions and millions of dollars of their advertising budget on cars and golf courses. And Keller Williams, you'll never see do that. And yet it doesn't matter. Consumer doesn't care. What does the consumer care about? The relationship and trust that you have with them. Period. In a story. Who really cares is you. You care about the company you hold their license with, and it's not about national branding. It doesn't matter. National branding doesn't work. Matter of fact, look at the company. The top 5. Where is the biggest company that we've known for years? We grew up called C21. It didn't even make the top 5 in the luxury market. And they're probably the most well-branded, well-known brand in the marketplace. And guess what? Does the luxury market care? But who has not heard of 621? Everyone's heard of 621, right? But yet it doesn't matter because the people do business with who? They do business with you. The agents do business with the company. Keep moving forward. Then we took the top. You know what? Come over here, Steph. This is what I'm really proud of. This is the stats for 4 Rivers, and I'm going to let Stephanie take over from here.
So this was just pulled from KW Heritage, Coldwell Banker, all of our heritage offices, all of the Coldwell Banker offices, Berkshire, and we combined them just for New Braunfels market share. This is a report we can run for any of the cities. There's some discrepancy when you pull from Central Texas versus Sabor. Some of it doesn't syndicate. So depending upon what you'd like for your own personal marketing, we can run these. This is just New Braunfels. So our market share is 15%. The next closest being 6 with Coldwell Banker. So really, really good stats, and it's all you guys. So awesome.
Everybody, I think you know, if you don't have this number in your phone, please put it in your phone right now. This is the contracts hotline. This is your first line of defense. If you have a contract question and you're not sure what it is and you need the fastest answer possible, Hank Bronstein knows more about contracts than any person that will ever live on this planet. He's incredible at what he does. He is the only person on Contracts Hotline. So I know that I'm not the best person on Contracts Hotline because I'm usually on the phone already when you call. It takes me a while to get back. We've tried to eliminate that problem by saying Hank is Contracts Hotline. It doesn't alternate between people anymore. When you call, you know you're going to get a right answer. You have to leave a voicemail. If he's on the other line, he gets so many calls. If you don't leave a voicemail, you're probably not going to get a call back. So please, again, put this number in your phone if you don't already have it. It's a huge resource that, to my knowledge, I don't know that any other brokerage has anything like this, and they certainly don't have a Hank. So please take advantage of it. It's a huge deal.
Okay. We have a safety device that we've been working with this last year along with Contego, which some of you may know that last year we made a couple of big, bold statements that we were going to have a safety device ready. A personal safety device that would be able to be purchased, and it would be a small service fee which would be attached to the wristband that would protect you in the event that there was ever any type of violent physical harm placed upon you. You could basically push the button on the bracelet, and it would call 911 and also work with the GPS on your phone. We are still in the process of getting this done. However, we have run into several roadblocks. We've had some beta testing on some of the units. It did not come back as well as we thought, so we have a new manufacturer that we are employing to make the device is durable, and also what we found is it has to be lady friendly. Sorry guys, what we found is, ladies, you won't wear something, even if we've done testing on this to know that many of the ladies will not wear something, even if it's safety oriented, if it doesn't look really hip and cool. Sorry. All right, I have a girlfriend that's, it has to look really cool or you won't wear it on a regular basis. So for some who actually made a pre-purchase last year, and if there's any in the room, I want to make sure that we're going to refund the money for the time being, because we don't want to hold on to your money until we get the device out in the marketplace, which we're hoping will be soon, but we can't make a promise. Having said that, what we did when we were able to still complete and execute, I think we've done a pretty good job on it, is we bought 15 Nest cameras. Who ever heard of Nest? N-E-S-T. Many of you have already heard of it. And they're actually very, very, not only portable, effective, and they've got wonderful HD quality video and audio that many of us are already using for surveillance or safety for our own home. What we did as a company, based on the approval of the Agent Leadership Council, unanimously voted in 15 units for our company. So we have 15 signs that say this, basically say for the protection of this house, for your protection, this house is under surveillance. Please enjoy your tour. So when you're doing open houses, the agent was able to put a Nest camera up on a small little tripod with a Verizon hotspot, which allows the agent to place this into the property, even regardless if there's Wi-Fi available or not. And when this is green, it indicates the video is on and working. As any consumer or open house attendee, being a buyer, or someone walks in the house, the video is rolling the entire time you're doing the open house. This is available for checkout at each one of our locations for the weekends, completely free to all of you as agents for the protection of you and your family. Folks, I cannot stress the importance. There should be no, especially, I don't believe any female or male, but regardless, anyone individually doing an open house without surveillance being provided. We've had instances in the past, and you've read enough news articles and seen enough video of realtors who have been violated, or sexually violated, and killed or raped because they're in properties where there was no one else available to rescue them. And this goes without saying that this is something we as a company take it very seriously, and I want these units every weekend to be checked out. And there's a video that we have, and if we could roll that video real quickly, and it'll explain the rest of it.
Awesome resource of having this Nest camera security system for our open houses. It helps the clients feel safe knowing that we've got security set up in their house. Makes other people feel safe that do come to the open house. When there's a lot of people there, you've got the signs up and everything showing that everybody's being videotaped, so it just helps that additional security.
We care about you. It's hard to believe sometimes, but we really do care about you. Sometimes we don't show it, but we care about your safety. I'd like a commitment. If you've raised your hand if you've used this device before. Anyone here? Yeah, you guys see some males, it's awesome. Well, you guys see great. I see less than 1% of the entire room use this device. That's a shame, because I don't want you to be a statistic. I had an agent years ago who was raped in an open house. Is that statistically not supposed to happen? My curiosity would be, if this camera was on and available with this sign in the yard, Do you think it would detract that from happening? Let's not make another mistake. Let's protect each other. Get on the bandwagon. This is available to you for free of charge. Please take advantage of it, because I don't want to be called at night to hear one of my fellow associates, friends, and KW family members ever hurt in the line of duty, okay? Because you're just doing your job. If you go to buy a car, what's the first thing the salesman does before you get in that vehicle? You can't go drive a vehicle without a driver's license and ID. And why the hell do we let people go into houses that we don't even know who they are, with all the valuables, personal items, and most important item of value is you? And we let them in like it's nothing. It's like government cheese. No. Let's don't be government cheese. Thanks. All right. Got the video? Does it work? What? All right, that's it. Let's get up. Let's bring back up here Garrett Brandt, Jack Hawthorne, Bo Blackburn, and Lisa, you're going to be doing facilitating this panel on frequently asked legal questions. Folks, you're going to take some notes. This is some good stuff we came up with here. Give it up for the panel.
All right, thank you. I'm going to call this our legal masters up here, our trio of legal masters. Thank you all so much for coming up. And what we've done is, with, I guess, all of us together, Garrett, you and I especially spent some time on this, going through a lot of issues, legal questions frequently asked, issues that come up that happen, what, average of 3 or 4 times a week.
Yeah.
Most of these are up all the time.
Yeah, these are items that either we've gotten questions very recently or seem to be recurring conversations that we have in the office. So we thought we'd bring you some of those and what we all, as the attorneys, want you to impart to you and tell you about these.
So we compiled a list of questions, list of issues. So we're gonna, just Randy, I'm gonna call on any of y'all, just who I shoot after the question and yeah. All right. Some of these we have talked about year after year after year after year, but they continue to come up and we're regularly has come up like that.
So to be fair, we talk about them day.
Oh, yeah.
day, so.
That's our sanity check when the end of the day we're okay, how many did you have? So anyway, yes, we've all talked to numerous days and days. Yeah. So first question, probably most popular. I'm going to ask, well, since you're involved in titling, we'll do that. Are title companies allowed to receive option checks? Why or why not?
When you say receive, I'm gonna be
Accept
a little
them
bit
from
more- okay,
agents.
there you go.
I'm sorry, accept them from agents.
No,
Well, gosh, you as well, you've got wonderful employees, your marketing people are so nice. As an agent, I'm just so busy, I just don't have time to take the option check to the seller's broker. And they're so nice, they come pick them up and they say, hey, I'll get it to you, no problem. Why is that a problem?
well, it kind of goes back to what Avis was talking about earlier with, when Garrett asked what's the top 5 issues that you see with complaints. It's the breach of fiduciary duty and the competency issue. The check is supposed to be delivered from one party of the transaction to the other, and it's delivered from.
Yeah, there's two documents.
Oh, there you go.
Yeah, I
I didn't know you had it. but there
I
you
was
go.
going to just interrupt you.
And the party who's supposed to be acting on behalf of the receiving party in that situation is the agent on behalf of the seller.
So really, just taking an option check doesn't mean they've received it
Correct.
officially. So who are the only 2 parties that can receive and sign for receipt of option check, which is on our first document here? I hope y'all have seen this document.
I think what you're getting at is the seller and the listing agent.
The seller and seller's broker, right? The only 2 that can actually receipt, which means what? Proof of receiving on behalf of the seller.
Correct.
Okay, on behalf of the buyer, excuse me.
And I'll even take a step further. So the title company is not responsible for either the parties in the contract. And if the title company is delayed, let's say the contract signed on a Friday, and you take the option money to the title company, they're closing up shop, they're not getting that in the mail on Friday, so they probably don't work on Saturday. And what if you do it right before President's Day weekend? Well, they're not in on Monday, so that option check isn't even gonna hit the mail until Tuesday. But the contract says up there on page 8 about the option money, that it has to be received by the seller within 3 days. Well, suddenly, and they're not business days, they're calendar days. You got Saturday, Sunday, Monday. Suddenly, the seller doesn't have the option money, and the contract says when the seller doesn't receive it, it's as if the buyer has no option, period. It's done. They don't get the 10 days or whatever you've negotiated on behalf of your buyer. There's no option anymore. You cannot terminate for convenience within that time period. So it's very, very serious that we get the money to the seller or the listing agent who can receipt for it immediately.
And thank you, this is real. Briefly, I think I've told this before too, but this actually happened. We had an agent, top line agent, notch agent that knew exactly what we're talking about. Had another broker's agent, had the listing, asked her to leave the option check at the title company. And she said, we don't do that. We're not allowed to do that, I can't. Well, I told the title rep to call me. When it's there, I'm gonna go pick it up. She did that, and her gut said no. She knew it was not there.
No, question regarding the option money. Say the 3 days already passed.
Well, that's what
And if the seller decide to accept that, did the buyer still have the option? After
Well, let me
the
just
3 days.
continue on this one particular thing that happened. She leaves at the title company, the title rep does not, for whatever reason, or maybe the title rep did tell the agent. 5 days passes, the buyer has to terminate for family reasons, wasn't moving to San Antonio after all. She tries to terminate, and the agent says, I don't have a receipted option check. And she said, now you remember you told me to drop it off the title company. He goes, no. So at that point, you're asking if the seller could have said, no problem, I understand? Not in this case. It ended up costing us the earnest
So
money.
then the buyer still have the option.
To answer that question, so I can't see who's asking something, but,
It's each time.
so if the buyer isn't able to deliver the option money in a timely manner, if the buyer's agent isn't able to, or the seller doesn't get it in a timely manner, whatever it may be, if the seller decides that they are willing to give them the option period anyway, even though it's delivered late, then they're absolutely allowed to do that.
And in this case, though, it didn't happen that way. The seller said, no, you don't have the right, and it cost us a few bucks.
I'm the buyer agent, will never happen that way. It will be always within the 3 days. But some buyer agent delivered the check to my seller after 3 days. I explained it to the buyer, the seller.
Oh, she's asking if you get the check to them, they don't deliver it. In other words, the seller's agent has the check, and they don't give it to the buyer.
So as a
The seller.
rule, anything that is delivered to you as a buyer's agent is deemed to have been delivered to your buyer. Anything that is delivered to you as a listing agent is deemed delivered to your seller. So if you get it to the other agent, you've gotten it to the seller.
I make my seller aware that they do not have to accept that check, but they decide to do, I'm okay, right?
You are absolutely fine. Your seller has the ability to show grace where it may not be otherwise earned.
Number 2, Garrett will talk to you about this. Go ahead.
Signed for by the agent.
Can you stand up?
Can you guys speak loud?
Received by the broker, could be any agent in the office, right? Any real estate.
Yes. But it cannot be a staff member.
Yeah,
It
be
has to be a
licensed.
licensed
Be
agent
licensed.
as an agent of the brokerage.
All right, Garrett, how long does a buyer have to deposit earnest money after execution?
Why don't you ask the audience that before he answers that?
Okay.
Because this is.
This is a multiple choice, we're gonna get to the multiple choice slide.
Yeah, read it.
Okay, so
Well, the contract.
what is the
says-
actual wording?
The actual wording says that the earnest money must be delivered with the contract, and it's not stapled to it. It probably have, probably a reasonable time.
Well, what is, Trek says a reasonable time.
Yeah, I helped write them, I know.
What does Trek mean by a reasonable time? Is it A, 3 days, B, 2 business days, or C, 24 hours?
Who says A? 3 days.
I said 3 days.
Who says B, 2 days?
B,
2 business days, sorry, 2 business days. And who says C, 24 hours?
Who didn't raise their hand?
Yeah, who doesn't know?
I see a lot of non-committals.
The answer is, now, when you look, you have to kind of dig down to have track say, really say what it means. So I dug down a little more, and it says what they mean by reasonable time is 2 business days.
2 business days.
So 2 business days, you got your receipt contract on Friday at 6:30, Monday's a holiday, title's not open until Tuesday,
So,
later by the morning, you know, who knows when we get there after holiday weekend. So you go, and so you got Tuesday and Wednesday. That's reasonable, I think. Right? So,
I can defend it.
is that, are we correct in saying that?
No, I said I can defend it.
Oh, you can defend it, okay. Most of it, you can defend it then when it comes out.
What about if it's a week? What happens if it's a long vacation and I'm the buyer's agent and I drop, I was at spring break vacation and I, with my kids, sorry, couldn't get it to you. And you, what happens in that situation?
There's no, Jack and I and Garrett and I can't look in the book and say, what happens if the agent is on spring break? We don't have a definitive answer to that. Any of those questions that you're asking about get decided by either TREC or by a judge and a jury. And TREC, under the scenario you just gave me, what if it's a week because the agent's otherwise just not take care of business? Well, TREC's not going to view that favorably. The judge and
They're going to say that's negligent.
They're going to say that's negligence, breach of fiduciary duty, and competence. However, if it's a week because the agent was on their way to deliver the check and they got into a car wreck and they were in a coma, TREC's going to say, okay, right?
So the definite answer is reasonable time is 2 business days, but if other issues happen, there can be special dispensation for that.
So you better die.
Spring break is not an excuse, Greg.
So coma is really the only excuse you
Coma
get.
is the only, if you're bleeding or dying, that's the excuse.
If you are in Cancun and just can't quite get the check over there in a timely manner, then your best case scenario, if your buyer wants to terminate, is probably that you're paying for the earnest money they're not going to get back because you didn't deliver it to them in time, and they wanted to bail out.
I will make a prediction that by the time that we're doing this 2 years from now, this will not be an issue.
Why?
Technology is going to solve this.
Oh, okay.
We already have, in certain areas, we already have in Texas where earnest money and option fees are being dealt with electronically, and it's coming to San Antonio. It's just a matter of time.
You know, awesome.
maybe a service.
All right, here, I'll go to you next. Number 3, what language is acceptable in paragraph 11, special provisions?
Pretty much no language is acceptable in paragraph 11. The contract reads that it has to be factual statements or business details, and I would add pertaining to this particular transaction between the buyer and the seller. So statements regarding the relationship of the licensed real estate agent to one of the parties, that's not where it goes. In fact, there's a whole paragraph just for that, section 4. Other just generic statements where you would use the language over and over again regardless of the nature of the deal does not belong in paragraph 11. They have to be factual statements and business details to go in there. One such thing would be, and I see this often and it's a good use for it, would be seller to respond to this offer within 24 hours or it's withdrawn. That's a good factual statement of business term between the parties, and you can put that in paragraph 11, but don't go beyond that without approval of
That's about it.
that guy. No, just him.
Pass it on. All right, thank you.
I have a question on that. Okay.
What was that?
Some buyer agent wrote it in paragraph 11 and say the seller will pay for the appraisal fee. Now, my question is, they do that, which one supersedes the other, right? The preprint or the paragraph 11. So is it best if we attach along the amendment, say the seller pay for the appraisal fee? What is it?
So the question is, the buyer's agent wrote into paragraph 11 that the seller was to pay the appraisal fee on that, and
And if that's in conflict with the other
Because
provisions.
You don't know which one
Paragraph
supersedes the
7,
other.
paragraph 7,
Right.
I think,
So,
addresses
It's
that.
best to
Yes.
submit.
So the question is, what happens in that scenario? That's a bad scenario. If you're wanting to write something like that, don't, right? Obviously, don't do that. If you receive it, if you're the agent that's received something that's conflicting, you either need to send it back to the other side and say, I don't understand what you've done with this. Can you please do this again where it makes sense? Or you give it to your seller and say, look, this is the best we've got. How do you want me to respond?
Well, my question, would it be better
It would be better not to do.
we submit the amendment?
No.
Well,
It
at
would
the
be better
end,
not
you've already had an agreement, so they may not
So the,
do it.
At the same time with the contract, at the
But
same
they're
time.
still not obligated to
At
sign
the
the
same
amendment.
time we make an offer.
The best thing you can do in that situation is put no additional language addressing it because you have a paragraph that specifically addresses in the contract. The entire purpose of paragraph 11 even says it explicitly in the instructions, is that it exists for items that are not otherwise handled by a TREC promulgated form or a paragraph somewhere in the contract. So if it's handled somewhere else, then it should not be in the paragraph.
They prohibit you. Jack, this next question is for you. Why is paragraph 21 so important to be completed when executing a contract, which is notices?
So I am going to pump out, and I'm going to give an answer that a lot of you guys have gotten in an email lately, which is I'm going to direct that over to our Director of Risk Management because it is an excellent contract question that I think he can answer.
So paragraph 21 is where we put in the notice for buyer and seller. And the reason you want to complete this is you want any notices, especially like a notice of termination or any other contact to the other party, to be delivered to that party. And you can't do that without contact information filled in there. So if you're representing the listing, if you have the listing side and the buyer brings you the offer and they've got the buyer side filled out, fill in the listing side, write that in there, make sure it gets in there. If you're on the buying side, you might even ask the listing agent when you're making the offer, hey, what information do you want me to put in here? Be diligent about this. If there's no notice here, if there's no contact information here, and a notice needs to be sent, by default, it's going to go to the agent that is on that side. So if a buyer's sending a termination notice and can't send it directly to the seller, they're going to send it to the agent. Well, what if the agent is Craig and he's on spring break? He's not checking his email for a week. Your option period is going to run out before the seller even knows that it's terminated and somebody's calling TREC. So please put this in here, get information, even if it's just a phone number, some way to contact that seller. Email is great for that reason.
Seller and buyer.
Seller and buyer, yeah, it goes both ways. So I see the seller side left blank more often
Right.
because the offer is written,
Well, the initial,
presented,
yeah.
and they don't know what to put in for the seller, and then the listing agent often doesn't add anything.
Can I ask, maybe you or Bo, maybe since you are defending this, let's say nothing was filled out and the buyer tried to terminate, and that is officially where the notices are supposed to be written, or excuse me, given, right? And you tried to terminate, but you didn't have any place to send it. What's the defense on saying, you gave me no avenue to send it? Can I still terminate the contract without any kind of repercussion?
Not a very good defense. You're going to have the contact information for the other agent, and under that scenario, you just need to send it to the other agent.
So, there you go.
Right?
I 100% agree. When in doubt, if there's nothing in that block at all, then the agents are the points of contact, which means the agents hold all the liability for any notices that are supposed to come in.
Thank you. Here, what documents or forms do not belong in paragraph 22?
So paragraph 22 is where we add additional provisions to the contract. And this is a big one on me. I've been writing notes asking, please do not put in the intermediary notice, relationship notice form, or the seller's disclosure, or the residential service contract disclosure forms. I see these attached on there. The reason why is you have a contract with business terms between a buyer and a seller. A notice about an issue outside of the contract, you're suddenly bootstrapping into part of the contract, and now they're business terms. We don't need the intermediary relationship notice to become a business term between the buyer and the seller. I don't believe it's a TREC violation. To me, it's just you're creating a problem that may not otherwise exist. Seller's disclosure statement gets brought into the contracts. Now suddenly it's a contract document that the lender could use and go through and maybe request additional repairs or other issues that come with that. You've also added a breach of contract claim if something proves to be false in it. Bo, do you see any other issues on that?
You hit that.
It does kind of still over, but doesn't mean those documents don't need to be submitted
Yeah.
to the office. It's on your checklist. It means it just does not attach to the contract because it's not part of it. So-
Absolutely, they still need to be part of the deal, the paperwork that comes in, just don't add them as a part of the contract. Does that make sense?
Yeah, what about the non-representation? If they've decided to not be represented, would that be a form you would want to add as part of the contract just to cover yourself? That both parties are not.
You mean a separate form that they've executed acknowledging that you don't represent them?
Well, yeah, Keller Williams has their own form.
Right. Assuming you represent the seller and the buyer
Right.
shows up, he's not represented, you have that buyer sign it, do you need to put that into paragraph 22? I don't think you need to.
I wouldn't. It's substituting for a buyer's rep agreement in that, just load it in the paperwork so we have it documented. And when I see that, if it's not attached, that's one of the things I reach out and ask for and say, please, we need to have this in the file. That and of course an IDS with that buyer too.
I don't think I could say it any better than Gary did earlier. Just a point of practicality. The contract is between the buyer and the seller. As an agent, you're a facilitator and you're part of that, but it's not your contract. So anything that has to do with you and one of those parties that is aside from the actual agreements of that contract really doesn't need to be included.
What about attachment A, the appraisal? We've got a lot of appraisals that aren't appraising. Can that be attached to it because you're saying if
Good question.
I recommend that attachment A, well, not even recommend, it should be attached in paragraph 22. The reason for that is an actual contract term that you guys are negotiating as part of the contract. It's not just something between you and the buyer or you and the seller, it's the buyer and seller agreeing to modify a term that is not otherwise in the contract.
That's a great question, and can I add on to that attachment A, appraisal language? We've had a lot of issues, and I think you might have too, where agents are saying that Keller Williams requires sellers to sign that. That is not.
It is absolutely not. I mean, I can tell you, I wrote the document as a listing agent. I probably would never advise my seller to sign it. But it's a buyer form. It's there to help your buyer out, and it's something that your buyer, you know, if you're in a multiple offer situation,
Especially.
or I mean, there are times that it can come into play. But if you do include it in the contract, it is not required that they sign it, but you should include it in the contract if you are going to use it.
When you say never, I presume you mean in our current market.
In our current market, there may, so
Maybe the market shifted.
Right, you would definitely, a seller would say, fine, I'll sign it because I want to keep the deal. Yeah.
If you've got something sitting on the market for a while and no one's making any offers and someone comes along, yeah, absolutely. But in the current market, no. And I appreciate that, though. That needed to be clarified.
Okay. Jack, this question's for you. What is the time limit for an appraisal to be provided within the contract?
There is no time limit for an appraisal. You are not actually required to get an appraisal. That is the problem. So as you guys know, on paragraph 2B of the third-party financing addendum, you have the ability, if the appraisal comes in low, you can terminate up until the day of closing. That does not actually require you to get the appraisal at any point within the contract. So there is no time limit. It's usually when the lender decides to do it. My recommendation to everyone is that either as soon as you're out of option at the latest or early, go ahead and order the appraisal. They schedule them a week out sometimes, usually more. And at that point, if you guys bail out of option, you can just terminate the appraisal before paying for it and having it done. But at least it's in the system, so it's not being done 2 or 3 days before closing.
So you're saying that the underwriter can come the day of closing and say, I do not agree with this property?
They can show up at the closing table.
They can show up, okay.
And I have that, not that conversation.
That's
I have
pretty-
a
that's pretty
conversation
important.
within 48 hours of closing. I have that conversation with an agent every single day.
So you must have read my mind on the next question. To address an appraisal deadline, when would be a good time to place that request?
I think that Garrett has some really great language that he could recommend.
Hey.
This would actually be a good.
I'm sorry, Esther.
Esther.
As the wife of an appraiser, the appraisal orders for most mortgage companies come from appraisal management companies. it is not uncommon for those appraisal requests to arrive 2 days before closing, which means that it will not make closing. So there is no way that we as agents can order appraisals unless it's a cash transaction or in some way outside of the realm of getting a mortgage through a mortgage company.
All right, let me clarify then, because I was overbroad. I would say request that your lender request the appraisal. You don't have the ability to do it yourself. Make the request.
Well, and Garrett, would you like to read the?
Yeah, so
Right.
lenders aren't parties to the contract, so you can't really put them on the spot too much, but you can make a contractual obligation that they need to try and meet. So I've drafted some language, and this is actually a good use for paragraph 11. Have this is obviously a seller putting this in, that the buyer is going to order and have completed the appraisal within 15 days following full execution. And then there's another 5-day period to make any objections to it. That bunches it towards the front. Yes, a buyer may have to pay for an appraisal even if they decide to walk away, but a seller can certainly ask for that. These provisions could be negotiated, but I recommend that if you think that the property is not going to appraise and you know the buyer's going to get one, have that done up front too, instead of it being on the back end and delaying all your closings.
So that language goes, okay, to be written in that special provision, or?
Jack and I are still
Okay.
going back and forth a little bit on that one.
We have a little difference of opinion.
Yeah, we do, and this is one of the most common complaints that I get on the broker lawyer committee, is the fact that we refuse, and we do refuse, to be really clear, and I'm one of the people that refuse to address this issue. So if you're mad about that, complain to these guys, but the reason we won't address it, and we will not, we're not going to give you appraisal language. We're just not going to do it. You can keep sending us emails. We're not going to do it. We will not, in the state of Texas, turn over the decision on the value of the property to appraisers. And this appraisal language, attachment A, any language that I've ever seen, takes over the ability for the buyer and the seller to determine the value of property in the state of Texas, and it hands it off to appraisers. And we're not going to do it. So, sorry.
So the second part of that is any objection to the purchase price? Is that kind of letting the buyer and seller decide if they want to?
I mean, I have more of a philosophical problem with this than I do I see some practical issues with this too, but it kind of goes beyond what I can say.
Could you add on there, of course, the final decision is between the buyer and the seller to determine the value of the property?
No, not really. Because
So
I think if you're using this language, you're defaulting, you're saying the buyers and the sellers are not going to determine the sale price. They're just not. We're going to default it, and we're going to let the appraiser determine what the fair market value is of real property in the state of Texas. And we just adamantly disagree with that concept and will not do that under the current makeup of the broker lawyer committee. We want the buyer and the seller to negotiate the purchase price and for that to be the price.
This is why people hate attorneys, by the way. We have 3 of us up here.
We can't agree on
that.
I'm sorry.
I wanted to kind of bring this all together. The reason that this language, and I think the reason that it came up, and why appraisal A exists, is because there are buyers that want exactly what Bo hates. They want to say, I'm going to offer whatever for this property, but I'm only going to pay what the appraisal is, and I'm not going to pay $1 more. That's where it came from. It became kind of a market trend, which is why the language that Garrett has came about. It's why appraisal A came about, or attachment A came about. I think special provisions is what keeps Bo awake at night. So there's a difference with down.
That's what adds the commandment to come back.
Yeah.
That's exactly.
So put this in there and then elaborate.
Since
You
it's
really
good
finish
to
that
follow.
command.
So I just wanted to kind of tie that up a little bit. It's kind of a market trend. It's not, I work in different markets, Bo works in different markets. It's more popular in some places than others. However, in San Antonio, it's a big deal right now. So that's why the language exists. If you're going to do something like this, please go through Garrett, because he can help you with the language to make sure that it's as tight as it can be.
One of the things Trek is doing, because they don't like this concept of really changing their forms on a systematic basis, is they're evaluating, like Ada said about the advertising, they're evaluating some rule changes that would strictly regulate the ability to do things like this. They haven't got it all the way through yet, but it's coming. This is This issue isn't going away.
Now, so this language isn't necessarily meant to just be boilerplate to throw in all your contracts. That would
Please
not
don't
be
do
what it is. It is to be
Yeah, don't prevent-
used when your buyer says, I need this, and you say, hey, I think I can help you on that, and then give me a call or an email.
I have a question. The buyer, the lender can control when to order, but to the report to come in, they have no control over it. Depend on how quick and how slow the appraisal,
Yes.
but they have 10-day turnaround.
So
The appraisal has 10 days, so 15 days a little bit too soon.
it could be. And again, this was something we just drafted yesterday as an example. It's going to be up to some communication with the buyer's lender, how long are appraisals taking, that kind of issue. What can we realistically expect? Yes,
But the
Greg?
lender makes the final, I mean, here's the thing. The buyer is the client in the relationship with the lender. The buyer can determine when the appraisal is ordered by telling the lender, if you want my business, I need you to order the appraisal now. Here's the money, order. It's very simple. Now, if the lender doesn't do so, that is a breach of fiduciary responsibility he has with the client, because the client's asked to order the appraisal. I don't understand why that would be that, it shouldn't take 2 weeks to order an appraisal if it's requested on day one.
If I would address that real quick, I think the biggest issue we have are most of our buyers that this affects are not able or willing to put up $700 or however many dollars.
It's not that they're not able, it's because no one wants to hold the bag. At the end of the day, at the party favors at the end of the day, no one wants to hold it and get stuck with the bill when the deal doesn't close the final days of closing.
That's correct.
That's why appraisals and surveys make our life hell.
That's right.
On the day before closing, they break up, and we don't. I can see both sides of it philosophically, but when we're being shot at the platoon is being shot at the day before closing, and they come to us with these issues, and my simple request is, well, I look at an appraisal like an inspection. Just get it out of the way, because you're going to spend the money regardless. Get it done. Don't wait till the last minute, because when it gets really serious at the end, the emotions are flared up. People want to bring lawyers involved, and then it's always an issue at the very end of the transaction when it could have been a lot smoother if it was done on the front end.
Well, I'm going to try to step out of the philosophical part and move to the practical. And I think from the listing side, you're not doing your job for your seller if you're not talking about this on day one. When you talk to your seller about what you're going to do for them, you need to point out that if they accept a contract that has a third-party financing addendum in it that gives the buyer this right, that they could literally walk into closing and say there's not going to be a closing, and in fact the contract has been canceled.
Correct.
You need to be having that conversation with your sellers on day one and explaining to them the real meaning and the real potential impact to them. You may have already moved out of your house, right? They need to understand that when they're deciding whether or not they're going to give that right to the buyer, because they give the right to the buyer, and then they're pissed off about it after the fact, and then they're mad at you because you didn't say anything to them about it. You show up at closing and you say, well, I knew this could happen. Why didn't you tell me?
Expecting something is much better than not expecting something.
It is much easier for you guys to have that conversation on day one than it is for me to have that conversation with them on day 50.
Jack, there's just real quick, there's some clients out there, all of us have had, I don't know about you, but as an agent who's used to sell, that are so anal retentive that by putting them in a position the day before closing, knowing that there might be a delay, and they're moving their stuff out, it may be a good idea on day one to negotiate a lease back for a few days. If you believe you might have that situation, then I think it's an ounce of prevention is worth a pound of cure. Just be a fiduciary to your clients. Use what the language are just telling you, and prepare the client on the front end so this doesn't happen. Because I hate to get all the way to closing, and we're doing open heart surgery the day of closing, and I'm literally got my truck open, helping the seller move stuff, or trying to move back in because of this kind of problem, or having to put them into the buyer into a hotel because of something that really the agents could have prevented, but if they just ask a lot of questions.
Even if they don't prevent it, Craig, I just want to, again, go back to the real practical. If they told the seller about it, that look, this is possible, this may happen, it's probably not going to happen, but it might happen. When it does happen, they're not looking at their agent saying, why didn't you tell me about this? They're looking at their agent saying, well, you did tell me about this was a possibility. and they're not yelling and screaming and calling Jack.
Oh, they used to.
Real briefly, Tim, you have a question?
Mr. Blackburn, you said that the ultimate decision and negotiation on the price between the buyer and seller and
Should be, yes, sir.
and the appraisal. But the lender is the one that is going by the appraisal, and they won't give the loan. So it ultimately is not between the buyer and seller, it's between the buyer and their lender.
I wish I could say that's the first time I've had this conversation, but it would be about number 100. You're wrong, and it's going to take me a little bit of time to explain why you're wrong, and I'd be happy to come talk to you after the fact. Be happy to.
Thank you, good question. Okay, this next question I want to toss up, I'd love to hear from all of you. What documents are needed to take listings for an estate? We've all had, and you come up and say, this is, oh, I'm the only heir, and I got this property from my father 10 years ago, and I can sell it. And later on it comes up that there's 6 siblings that never knew, that. So who wants to answer that question? All of you.
I'll talk about best practices. I mean, I think if you're going to be representing an estate, which is like an estate is very much like a entity or a separate existence. If I was going to be representing an estate, I would say, can you show me some documents that establish that, number one, there is an estate, and number two, that you're the person that has authority to act on behalf of the state. We had a claim late last year where we were representing we were representing what we thought was an estate, but we were hired by someone who told us they had the authority to represent the estate, and they just flat out didn't. And when first conversation I had with the agent is, well, how did this happen? And she said, well, I didn't really ask any of these questions. Did you ask this? Did you ask this? No, I didn't know I needed to, which is, I presume, why this is on here. So I would ask, because you don't need to know the exact terminology, just say, can you give me some of the documents that show there is an estate, and can you give me something showing me that you are the person that is I sometimes say the decision maker for the estate. And I need those because I need to make sure that the listing agreement is done correctly, that I have the right parties in the listing agreement. That would be my answer.
Would it be kind of a good idea to maybe get that information, maybe take it to the title company?
Yeah, that's what I was just going to say. Whatever you get, you're going to want to run it by the title company, especially if you have any concerns about it. If it's a good client, you know them well, you know the story, you get a letters testamentary or letters of administration from a probate court, and they're dated very recently, you're probably talking to the right people. But ultimately, the decision to pass title is going to go through the title company. So you want to take it all to the title company and have them do some brief research, make sure that a probate's been open, make sure that there hasn't been muniment of title by the will, or any other thing, affidavits of heirship may come out. Let the title company add any additional requirements that you may need before you take that listing.
We had one in Dallas recently where the poor agent got it sold twice, got it under contract twice. The first one fell out. The second one was like 2 days before closing. An heir showed up and said, he doesn't have the authority to act on behalf of the estate, I do. And basically said, because he hired you, I'm not going to use you, you're out. And she was out. There was nothing we could, legally there was nothing we could do about it.
Sure, so my 2 cents on this comes from rolling around in the trenches with you on a day-to-day basis on probate sales and on estate sales. As a rule, if someone comes in and says, okay, my mom died, my dad died, first question, all right, do you have a will? A lot of times the answer is no. If it's yes, fantastic, let's take that to title and let's check it out. And let's have title look at it first, because there's nothing that I hate more than for you guys to give me contact. I've been working this deal for 3 or 4 months, and we got everything in a contract, and exactly what Bo's just talking about. We found a long-lost heir who said no, and even if they have no authority whatsoever to sell the property, they can block it. And then you have to deal with that, and that's not a fast process, and it's not a cheap process. It is much better for you guys as business professionals to say, okay, instead of potentially wasting 6 months working on this deal, let's do a little bit of homework with my client up front, take it to title, have them evaluate and say, okay, these are the people you should be concerned with. If there is no will, That's more of an individualized conversation that we can have, and that's when you can reach out to me or Garrett. We have these conversations literally every day. They're airship affidavits, they're things title can do, but ultimately, underwriting counsel answers to a higher power than any of us. That's who we have to handle. That's who we have to deal with and who's going to make the ultimate decision. So let's get that out of the way first. And just as a caveat, because I don't think we have a question on it, the exact same thing applies to divorce. If you have a divorce sale, let's do a ton of work up front to make sure that you don't waste your time down the line.
Yeah, I was gonna say, I always use the terms, if you've been in my contracts class, red flag. If you're at a listing appointment, if you're talking to someone saying, oh, I'm divorced, or I inherited this property, boom, right there, stop and go, can I see some documents, because I need to make sure everything's, I'm sure it is, and just say, we just need to vet this, and I'm gonna take things off, and make sure we drop it down every down across the T. So yes, any divorce, estate, anything.
Also, just real quick, if you guys do have a divorce, and if you're contacted by an attorney who says, we'd really like for you to sell this house, or you have someone that says, I'm in the middle of a divorce and I want to sell my house, please reach out to us. We actually have language that we can give to the attorneys to put in their court documents that says exactly how the listing will work, exactly who can sign, what the ratios are, how everything works, because a lot of times divorce attorneys are not real estate attorneys. They say, Bob and Linda are getting divorced, Linda gets the house, they can sell it in 90 days. Well, the language we send them is about 3 pages long on how it's going to have to work, because as anyone here who's worked a high conflict divorce knows, it is not that simple. So please reach out to us. That we can make your life so much easier.
Real good information on that, thank you.
Lisa, you have a question?
Oh, I'm sorry.
So all of that is in terms of when you're presenting the seller of your estate, and there's a block, there's a, unknown there or whatever. Is there anything that we can do for the buyers to kind of
Make them feel comfortable, and they're on the other side of the contract, it's gonna go through. Is that correct?
Set expectations.
Great question.
Yeah, set expectations that closing is likely not going to happen on the closing day, that there will be problems, and then if you come in faster, fantastic, but if you're getting into purchasing from an estate, oftentimes it goes with no hiccups whatsoever. If there is a hiccup, it usually is a huge delay. So just setting expectations up front is really the best, at least in my opinion, the best thing you can do. Regardless of what the question is, regardless of the situation, set your expectations up front to make sure your clients know what could happen so that they can get it out of the way when they're happy about this new property, not down the line when they're angry at everyone.
Can I just add on to that? That's a great question. And can the buyer call the title company and say, listen, I'm under contract with my buyers, and they'll be crushed if something happens, and I understand it's a mistake. Can we talk about that? Is that okay?
Yeah, that's
Good
what I
idea. Okay. Thanks. That's good. I'm sorry, one more on this one.
Slightly off subject, but corporation in a similar situation. I've got a guy who says, me and my lady formed a corporation and we want to buy some property. What do I need? Articles of incorporation? Do I need all of that, or is that something?
You would want to send an email to me or Garrett. Depending on what the entity is, we may need the operating agreement, articles of incorporation. It really just depends on what level of entity it is and what their structuring is. Most of that is going to be a very brief conversation that we have with you, or we give you an email to copy paste and send over as if you wrote it, and that way we can kind of help you discern. And then we're going to, just like divorce and probate, we're punting the title. Make sure the title looks at it and says, yes, this is what you're going to need, because they're the ones that decide. And I think we have one more question in the very back.
This is a little bit off subject, sort of, but I just had a property and it became an estate during the transaction. I was representing the sellers. And there was no survey on the property, and that was to be taken care of at the seller's expense. And I contacted title, and they were like, we've already ordered a survey to be done. And I had someone that was going to do the survey for us, a company, and my sellers were very cost conscious on everything. And the title officer just told me, well, we were asked by the lender to do it, so we did it. I mean, is there just carte blanche when the seller's paying for a survey? I was really taken aback by that. It was a local company here in New Braunfels. But I just wondered, how do you handle that?
So the question is, down at the top, it go per contract and order per, however the contract's written. I believe that's
the
well, it's per contract. They're following the contract, kind of to the letter of the.
The title company is required to follow the language in the contract. And if the contract said the seller is paying for the survey, then the seller has the authority to pick the survey.
Okay, that's what I thought. Thanks.
Good question. Okay. This next one, and there's just one answer to this. When must the information about brokerage services and consumer protection notice form be attached or linked? Anybody have an idea on that? Who said always? Always.
I believe the collective mumble was correct.
Yeah.
I think it was always.
Always, is that correct? Everybody agree? All three agree?
Anything that is consumer facing should have the IABS and the protection notice on it as a rule. So when you think about everything you do, if it is consumer facing, if someone out there is going to see it and say, you know what, I think that person sells real estate. That includes your personal Facebook, business Facebook, Instagram splash page, Twitter splash page, anything that you use to market yourself as a real estate professional, they should be able to follow back and find the IABS and find out who your broker is. Ultimately, that is the biggest concern. That's why, in my opinion, that's why this rule exists, is so consumers can go to who's in charge. If they can't quickly find who's in charge, we're probably going to have an issue.
This next one goes into advertising. I think Bo, you and Davis kind of touched on this a lot. Unless you're an LLC or a corporation who has a real estate broker managing, you may not use the following terms in your name. And I know she said that there's a lot of changes coming up with that, and there's no ongoing task force, but I think she said Katie barred the door after that happened. So we have put together a list of what we know, realty, associates and associates, real estate company, or properties. Do you agree with that? Okay. Anything else you could add on to that kind of language or anything?
No, and I think what I took away from what Ava said is there's change on the horizon. We don't know what that change is.
They are testing that out, by the way, because we represent market centers in different areas. I know that there are, just to see how it works, we've had track enforcers drive through and actually just pick out for sale signs, bus stop signs, park benches that had advertising on it, and those people were sanctioned because they were out of compliance. So I think they're doing a trial run right now to see how enforcement's going to work on a big scale. If you're using one of these, I guess, modifiers in your name, understand that, and as we've had this conversation, it's been in the last couple of years, it's not in compliance. Historically, no one's been sanctioned for it. Eventually, and it's probably sooner rather than later now, you're probably going to be looking at some rebranding or you're going to get fined. So just, I might add that into your budget for the future.
Is there a question? Okay, Brad?
So on the previous slide, it said if a broker manager. So if you have a broker license on the team, you can't use it.
If you have a broker's license, then you can use these what do you call them? Monikers? Jack's smarter than me. Monikers? Yes, if you have a broker's license.
Even if you have a broker's license and you're sponsored under a broker as well?
I believe
That is my understanding.
Okay, good question. Anybody else? I can't believe anybody else wouldn't have questions. This comes up all the time. Anybody else?
Over there.
Yes. Coming soon. Yes, they are.
So the question is, I'm going to modify the question a little bit. How do we handle coming soon signs? Is that fair? So you actually, once you have an active listing agreement, you are required to put that listing on MLS for a very short time period. You do have the ability to get an extension from MLS for up to 14 days.
14 days or permanently.
But that is a request you have to make. Action has to be taken. A coming soon sign that you just throw out there, if you have a listing, that listing's active. You're supposed to put it on MLS. There are things that we can do. You request it from MLS to get a delay. As a rule, I do not recommend coming soon signs unless you do the actual physical request to track and get authorization to do it.
And that's a form for.
I'm sorry, say the word, not MLS.
The board, that's a form from the board that's called non-MLS listing service.
Four Rivers. Say more Four Rivers.
Or Four Rivers. What they're saying is there's two choices. It explains to the seller what can happen when you don't put your property on MLS because you're not being completely marketed. You're a distance of competition, right? And there's two choices. 14 days from the day you sign the listing agreement or permanently. One of the brokers has to sign it, and you send it in, you file it with the board. If they, I understand this, maybe I'm wrong, but I believe I understand this. If they change their mind a month later and go, oh, I have permanent, but I want to put it back on, I believe you have to redo the whole, and you have to redo the whole listing agreement. Because it's kind of like, well, let me put it out there permanently, and I'll say I want it permanently, and then, a month, 6 months into it, or 6 weeks into it, they go, oh, I changed my mind. I believe they require you to totally amend or recreate this.
Yeah, start the whole new listing agreement.
Start the whole, yeah. So, does that answer the question? Is that what you were asking? Okay. Anything else in this? This is kind of important. Anybody in the south yet there? I think this is yours, Garrett. What disclosure documents have the highest rate of errors when submitted?
So really two stand out in my mind. It's the seller's disclosure statement and the lead-based paint addendum. I routinely see these be with errors more than any of the other disclosures. Seller's disclosure statement, yeah, so page 3, which is over there on your right-hand side, I've highlighted the part that always seems to get missed, and that is where you fill in the amount and frequency of the mandatory HOA fees that are due. And Texas Property Code requires that those two pieces of information be listed. You can add the HOA name, you can add the manager name, the number, those are great, but the Property Code requires that you list the amount and the frequency of those payments, and it has to be in the seller's disclosure document here. And so if you take a listing and your seller says, yeah, I have one, make sure they put that in there. If you are representing a buyer and that seller's disclosure statement comes through and you know it's in a mandatory HOA and that's blank, send it back to the listing agent and say, hey, would you mind putting this in? Because my mean old grumpy compliance officer is going to reject it and you're going to have to do it anyway. Not you, the seller. Obviously, we don't want the listing agent doing it. Make the seller do that because that's probably about half of all times that comes through. I see a hand.
I've actually had that happen where I've had to send the disclosure back because of missing information, and the agent responded like kind of instructed my client on how to fill out the seller's disclosure. So she had me email all the questions that were on there so that he could respond to the email. Is that?
That seems. It's not telling them how to fill it out, it's telling them, please comply with Texas Property Code that requires the amount and frequency be listed. And then the seller needs to find that information and put it on there, so.
It always amazes me how many people they pay a bill every month or quarter, and they've done it for 10 years, they don't remember how much it is, who they pay it to. Then I got to thinking, I'm not even sure if I know. It happens.
So the other form being the lead-based paint disclosure, you all know the cutoff year for needing this is? Yes. But I also know that FHA, if it's built in 78, and if it's an FHA loan, please include this also because FHA, they're going to say it's required if it's built in 78, but that's a caveat we can address on the side. But the main thing about this is I don't get it back with something checked in C and D2 is always left blank, it seems like. Make sure that those get checked by your buyers when that happens. The last thing I often kick that back for is one of the two agents or both of the agents haven't signed the form at the bottom. So those are very, very common errors and they account for well over half of the times that I have to send something back when these come up in the document. So that's kind of my personal pet peeve is just you not taking a moment to look through and say, yeah, that needs to be completed.
So how important is the lead-based paint?
Well, it's a federal law, and the fines can go up to $10,000. So you decide. But here's an interesting point too. Who is actually required to give the buyer the 16-page pamphlet on protect your family from lead in the home? Anyone know who's required to give that to the? Actually, no. The statute and the form say the seller is responsible for complying with the statute. So it's actually the seller's obligation. Now, these are electronic. It's easy for the buyer's agent to get a copy of electronic, shoot it to the listing agent, and say, you need to make sure that that they have it. I guess if you're on the buyer side, you have that, you give it to the buyer, but the listing agent ought to have it, and send it out with that electronic.
Yeah, that pamphlet's on MLS form, zip form, it's on.
So anyway, those are the forms that I see most.
Question? Evelyn?
I was just going to say, kind of a good rule of thumb that these guys behind me told me is when the additional docs are loaded and you're going to write your offer and you see that SD is missing something like that, check the
put it back right on the listing agent.
But you have to
That gets him to do it. I mean,
Yes, we.
On my listing, prior to 1978, I download the booklet, pamphlet into my associate doc.
Okay, so you download a pamphlet into the Associated Docs.
Is that considered delivered? If it's loaded on the.
Well, the
associated-
buyer, the check the box there on D2 is that the buyer has received. And so the buyer needs to take a little responsibility saying, I have received this pamphlet. And if it's not, they need to ask the agent, hey, where is this pamphlet? And then the agent should reach out again.
Right, they have it.
But I know a lot of them just check the boxes they're supposed to. And
But just having that on there does not constitute receipt. They have to check the box for
They
receipt.
have to check the box, that's what D2 is all about. The other thing, just quickly on the seller's disclosure, I get this asked a lot, what about vacant lots? Do we need a seller's disclosure on a vacant lot? Well, the law requires that the seller disclose any known defect. And so even on a vacant lot, there can be known defects on that. It's a good idea for, if you, especially if you have a residential lot, Seymour has a good form that's developed just for residential lots. It goes through the checklist, a lot of things that could be on there. It also has a place for mandatory HOA fees because a vacant lot could be in a subdivision with mandatory HOA fees. So do that. If the property is truly exempt from needing that, it's an estate, it's a government agency, it's a lender foreclosure situation, it's from one spouse to the other. I know what those exemptions are, and if it comes in and you just say, hey, this is exempt and here's why, I'm done bugging you. That's good. Anything else? Yes.
Why does Shrek have a
I'm standing up so you can see me.
Okay, yes,
I'm
sir.
really short. Craig, have you ever been, has the feds ever come in and checked this and fined you for this, for the lead-based paint addendum?
As of today, no.
Well, I know someone who was in New Braunfels. So just for your information, ladies and gentlemen, the fines for not doing this form properly start, and I could be wrong about the amount, I think they start at about
It's
10,000.
10,000.
It's 10,000.
And they go up from there.
No, I don't think people realize the two biggest forms we get, that we will get deemed on if we don't have, is lead-based paint is a federal. And the most lawsuits we've ever had, always, revolve around the seller disclosure. And when you don't take it serious, and your client's not gonna take it serious, then that's where we have problems.
This was the feds coming in and checking in an office. It took a long time.
I would venture to say though, out of as many transactions our company does,
You've never been checked.
we have a very high percentage of very well, yeah, I agree. Hey, there's a level of doing business, Esther, and that's why we do these meetings once a year, and out of respect to every one of you, thanks for showing up, because we take this very seriously. Because if you get sued, believe me, these guys will tell you what it feels like when you're on the stand. And it gets real personal, and a lot of times it has nothing to do with what you did in business. It has to do with your life. And then when they go to depositions and they turn your life upside down and make you feel like a complete loser, you'll know what you're doing. This happened to me. And so I'm trying to keep you out of court and keep myself out of court. What Esther just said, it's not even the money. Sometimes it's the humiliation it puts you through. We had realtors literally want to quit the business because of failure to, it's just negligence more than anything else. Usually it's not you're a bad person, it's just because you fail to recognize how important it is.
Can I just real quick clarify something on that? Is it, let's say that there was a signature left off or something, is it everybody, even if I'm the selling agent, the buyer's agent left her signature off or his signature off, and the feds come in and nail us, is it everybody that gets fined? Or am I responsible for that person signing it? Should I complete the transaction if it's not totally complete?
Depends on who's looking. If my understanding, if the federal government is looking, they're going to be looking to see if the seller complied with their duties. And I don't even know if that would extend to the brokerage or not. I honestly don't know. Esther, I've never heard of that, honestly. I'd love to find you after and ask you a little bit about that. But my understanding of the statute is it's a duty on the seller. So I don't think that from the federal government perspective, I don't think they would necessarily be looking at brokerages. Again, Esther, I believe you. I'd love to hear what you have to say. But from other people other than the government, if the lawyers bring in a complaint, that you can be assured they're going to be blaming the buyer's agent if it's not there. And it's a pretty good argument right? If there's a statute saying that this is so important that the federal government is putting a duty on the seller to give this to the buyer, it's a pretty easy argument to make that the buyer's agent has a duty to make sure that their buyer gets it. That's a pretty simple argument for a buyer.
And that's a good, yeah. So this is the part, yes, I skipped over you earlier.
Why does Shrek not have a land disclosure form?
Good question. I jumped in, I probably shouldn't have, but I can't necessarily speak for Trek like I am Trek, but it's probably, on the broker lawyer committee, we have something we call the 5% rule. And basically what that means is if whatever issue we're looking at doesn't impact more than 5% of the transactions or the things that we see on a regular basis, we just don't deal with it. And I'm guessing there that there really just aren't that many issues that get generated that would necessitate a form that we would require sellers to use when you have a land deal. I'm just guessing.
Good guess.
Is there an unapproved land?
Safecore has an unapproved lot.
I think even TAR has one too.
Yeah, and TAR might have one as well.
Okay.
Yeah.
Transaction requires the Keller Williams
I can't hear you.
Which transaction requires the Keller Williams Heritage affiliated business arrangement disclosure to be included?
I'm going to say all transactions require this. We have such a wide variety of affiliated business arrangements that you're not sure if one party to it's going to be involved with a title company, an insurance company, a lender. Now you may say, oh, my buyer's not using any of those things, we don't need it. It's not whether or not they're using it, because it's a disclosure that we have a relationship and there's a potential that we're getting money. It's just letting the buyer know. It's a consumer notice that they can make an informed decision of companies that maybe the agent says, hey, I've got a really good relationship with lender X over here, and now we've disclosed to them, by the way, we also have a business arrangement with lender X, and they can decide whether or not they want to use that lender. So it has nothing to do with whether we're using those companies. It's a disclosure of our relationship. So please include them on all deals.
So that they need that for the approval of the file, for one thing.
Yes.
Those are any,
Yeah, this
something
is-
happens if it doesn't get
Oh yeah,
lost in the cracks?
Esther, this would be one that we know for sure the federal government is very, 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 very interested in this. Although when we come back next year, we may not say that depending on our current administration, but right now the CFPB is very, very, very interested to make sure that these forms are utilized on transactions, and they are very punitive. It's not 10,000, it's more like 10 million. The fines that they levy out for failing to do these things. So this is very serious. Craig and I talk sometimes. He'll say, you know, what do I need to be looking at? And I'd say, well, you need to be looking at the little things, but you also need to be looking at the business killers. This is a business killer. This is a put Craig in bankruptcy type of thing. Please, please, please use these forms, because they will come in and be very aggressive on their fines.
That means I can't buy drinks afterwards, so.
We'll be buying you
Now we
drinks.
get the bottom line.
We'll all be buying you. All right, thank you for.
Lisa, can I ask a quick question?
Sure.
Okay, on that form, it says the home that you are purchasing. So that's confusing to have the seller sign it, because they're like, I'm not purchasing this home, I'm selling this home. So the wording is very confusing between sellers who are asked to sign that. They're like, why would I sign this? I'm not purchasing my home, I'm not gonna work with you guys.
That's an excellent point, and I agree, it's confusing.
So the question is, the answer is,
We need to modify it. It's
Add in selling /
someone's been reading their forms, that's awesome.
Oh, I thought we were talking.
I think it was
Disclosure, it's a disclosure, but the,
good point, and what noted, and we'll work on that.
yeah,
Jack
thank
will work
you.
on that, or Gary will work on
Yeah.
that. Or
Thank
Craig,
you.
or somebody.
I'm working on it.
Julie, can you make a note?
Is Julie still here? She's missing me notes on last year. Okay, thank you for that question. Policy, KW policy questions. Forum property management, I think y'all covered that. That was one of the biggest hitters, right, in the issues. I know we went over pretty thoroughly, but just repeat, just summarize again, or?
Sure. You can only manage property as a professional if you are a broker or you are sponsored by a broker who has given you the ability or permission explicitly in writing to manage property. That is it. So anyone, and it's going to be in my non-negotiables that we'll go over in a little bit, but if you do not have permission from the brokerage or you're not a broker, then you cannot manage property. If you are, you need to let us know immediately because you're not covered by E&O.
What about your own property?
You are able to manage your own property. You're not able to manage property as a professional for other people.
But not through the company, but not solicited. But not solicited through the company.
Well, if it's we're gonna hit property management in a more detailed way in a little bit. So you can hold on to baby breath. Don't be excited.
More to come. Okay. Which license holders can be paid a real estate commission directly, including referrals and bonuses? Maybe y'all who wants to answer that?
Brokers, only licensed brokers.
A real estate broker can be paid directly for all real estate commissions and bonuses.
Correct.
Only?
Correct. Including entities. They have to be
Including entities.
Licensed brokers.
Okay.
What about a good friend and like just gave me a good referral?
It depends on how good of a friend they
You
are.
can buy them a gift valued at $50 or less, Craig, and it cannot be a cash equivalent, so no Visa cards.
Is that
You can
for-
treat them to a steak dinner.
Let me ask that, I'm glad you brought that up. $50, is that just for terms of deductions, or is that literally you cannot give anybody else a gift, or anybody that refers you that's not over $50?
There's a specific track rule.
Okay, all right, that's, I want to make it clear, because well, I'll just give them, $2,000 and I'll just write off 50. But really, it's an infraction to even pay them more than $50 or a value of $50, correct?
Absolutely.
That is correct.
Okay, everybody, I want to make that clear. Yes, Tim?
In some transactions where the real estate agent that's representing the buyer, and I don't know if it falls under this, but it seems like it could, if they take part of their commission and give it to them as a gift, does that fall under the same thing?
To their own buyer,
Yes.
is what you're saying, sort of a...
Yes.
I think I understand what you're saying, and correct me if you think I'm wrong, but I think what you're saying is instead of taking a 3% commission, I'm going to take a 2% commission, and we're going to adjust the sales price accordingly? Is that, no?
Once they get their commission check,
You're already too late.
Yeah, it's too late.
Once a commission check has been cut, you're already too late. If you want to do something like that, if you want to give your client cash in hand, really the only way you can do that is to take a commission reduction and apply it to their closing cost. Because that allows them to not pay that money at closing. That's
right.
The only way you can do it for more than $50. Yes.
Obviously, it has to be on the closing statement.
Sorry.
What?
Obviously, it has to be on the closing statement.
Yes, it would need to be on the closing statement. It needs to be in the contract. Oh, Ms. Stephanie? Oh, Ms. Lori?
Okay, so I recently had a new agent that I'm mentoring call through some old buyer leads of mine, and one happened to be a lender who said, I will send you buyer leads if you pay me a 25% referral. And I just want to give everyone a heads up that I take that as not being right. Like, we can't do that, right? Can you clarify that?
According to CFPB, you cannot pay a referral fee for business to a lender, and vice versa.
When we're talking about the millions of dollars in fines that actually just happened in Portland, Oregon, a couple months ago now, 4-point-something million in fines, and one of them involved the Keller Williams agent out there. But they came down heavy on the lender, but they didn't go lightly on the agents either. So they take that very seriously right now.
Thank you, good question.
Valerie had a question.
Okay, Alan?
Regarding, I've had this come up several times lately regarding the movement program for buyers receiving a portion of the commission. Lenders, you need to tell them up front, and some of them think that it's illegal. So we should let everyone know up front and get help if you need to, because you certainly can get back part of your commission.
So in an effort to paraphrase that so everyone can hear it, if you are going to do a move-up program, if you're going to do some type of commission reduction, you know about it up front. I know sometimes it's thrown on you toward the end to try and lock you in the deal. But if you know about it going in, then you do want to let the lender know up front, because some lenders are uncomfortable with it, some of them don't know how to do it, and depending on the loan, sometimes you can't do it. So, yeah, so you want to make sure up front that you fully discuss, look, we're doing a move-up program, I'm rebating 1% of my commission, you guys, and there's nothing wrong with going to the lender and saying, you guys tell me how you want me to do that, and make sure that it works for your buyer. That's the best way to do it.
Thank you. Okay. Bo, this will just last.
Speak up, at least we can't hear you.
No, my mic's off.
Hello?
Okay. Bo, this last one is for you. I think we talked about it earlier. What constitutes procuring costs?
Not trying or intentionally trying to be
That's broad, I know.
difficult on this, but I tell people when I teach about procuring costs that it's a lot like beauty. In other words, it's in the eye of the beholder. And you need to, when you think about procuring costs, the first thing you need to understand is who is the I. It is almost always another agent. Almost all procuring cause disputes are arbitrated and not sent to juries. And the people that make the decision, the arbitrators, are other real estate agents. So if you have a listing agent who has never in their life had a buyer, they're going to have a very different view of what procuring cause is if you have a buyer's agent on the panel who's never had a listing. So telling you what procuring cause is not exactly helpful to you to try to understand how a particular dispute is going to get turned out, because it depends on how you view procuring cause. And I bet if I explained procuring cause to you and then said, what do you think about this situation? Half of you would go over here and say, I think it's this, and the other half would say it's this. But with that kind of caveat, procuring cause is it's the cause that originates a successful transaction that is uninterrupted. That's kind of the best way I can do that in layman's terms. If you guys can think of a better way, please chime in. But it's a cause that starts a successful transaction that's uninterrupted. So an example of that is if you're representing a buyer, even if you don't have, obviously you're not going to have a buyer's rep agreement if you're worried about procuring cause. If you're showing a buyer a house, you take it to the house, you show them the house, and then that buyer ultimately ends up buying the house, you have an argument that you're the procuring cause of that sale and that you're entitled to a commission. That's kind of the big picture concept of what procuring cause is. One other real quick thing about procuring cause is a contractual issue. Most people have no clue that it's a contractual issue. The concept is that you have a bilateral contract. And a bilateral contract can be accepted by performance. And the contract has to be offered and accepted. So the offer almost always is contained in MLS. If you're a listing agent and you put a property in MLS and you offer to compensate a buyer's agent, that can be accepted by performance. And the idea is that you caused something that led to a successful transaction. And that something can be a lot of different things. So the listing agent is made an offer, almost always through MLS, and a buyer's agent performs and therefore accepts the offer of compensation. That's probably the best I can do in short.
I agree. I'm mostly practicing in Colorado when I did real estate law. In Colorado courts actually defined it as an unbroken chain of events that led to a successful transaction. And I don't think that's Texas. It's called case law, but that's a good way of looking at it, unbroken chain of events. So if you show a buyer X a property in November and you don't talk to them again for 4 months, and then you find out they're under contract with that house and it's closing, there's probably a broken chain of events somewhere. You know, there's going to be an immediacy to that. That's going to be a nexus that needs to be touched in there as well.
So you said you showed them in November and then never talked to them again, all of a sudden you found out it closed some other way, some other agent.
Months later.
You have no ownership of that, or you've not gone through with the unbroken chain.
Right.
Okay.
So, yeah, that's kind of an extreme extreme example, but it gives you the idea of what it means to have a broken chain of events versus a continuous chain of events. Anyway, it's always going to be
So
a case-by-case basis.
Communication after you show in November is a key. Keeping up, that can happen too. I mean, anytime you show and you communicate, gosh, I've shown 100 properties, and we've been communicating, we've had dinner 3 times, and all of a sudden I find out the first house they showed, they're already under contract. How would you handle something like that? If there was a, okay?
So if you're showing somebody property, and then the best example that I have normally is I'm working with Bob and Sally, we've been looking at houses. We looked at 40 houses in the last month. I went for a long weekend with my family, and they saw something on Trulia, and they wanted to go out, so they just called another agent, and they went and saw it, and that agent wrote it up. At that point, you are, I hate to punt and be a lawyer about it, but this is why you have 2 lawyers on staff. That's when you want to send me or Garrett an email and say, guys, this is what's going on, because that is going to be a case-by-case basis. We're going to have to go through everything, and we're going to give you a very unbiased, realistic answer. A lot of the times my answer is, you may or may not have a claim, or you do have a claim, but your expectation is incredibly low of success, which is usually a lot more likely. You also have to decide, okay, am I willing to sue my client? And you have to decide how much getting smeared online for the next 6 to 8 months is really worth to you.
And track and play.
And almost a guaranteed track and play, and lately a BBB complaint. Better Business Bureau has been super aggressive lately. So understand that if something like that happens, we encourage everyone to reach out. I mean, I hate to say that it happens every day, but it happens every day. And you guys have people that try and screw you over if something happens. So please make sure you let us know, and we'll take it on a case-by-case basis. We're going to request a file. We're going to look at the text messages and the emails and say, look, based on what you've showed us, X. And we'll go from there and figure it out.
Just real quick supplement to what Jack said. Last I'm going to finish with that. You shouldn't talk about procuring cause without the kind of companion to that, and that is if you do not have a written representation agreement. This obviously applies to the buyer side, as equally to the listing side, but it comes up on the buyer side more. If you do not have a written representation agreement, you cannot go to the courts in the state of Texas and ask to get paid. And there are no exceptions to that. Even if it's you're sitting at dinner with your pastor and your client, and your pastor is willing to come in and say that the client promised to pay you. The courts in the state of Texas have said, not our problem. If you, and they put this in writing, if you do not care enough to get a written agreement, we don't care if you get paid. And that's just as simple as they make it. So if you don't have a written agreement, we can't help you suing your client in a lawsuit. We can help you with procuring cause, but not in a lawsuit. And then I want to follow up a little bit on what you said and kind of preface this. You guys, I don't know if y'all, I'm sure you did, don't say this, but I saw the tweet in the publication that y'all, Keller Williams as a whole, is the #1 training company in the United States. Yeah, that's right. That came out in January, I think. It was right before family reunion, I think. That's a really cool thing. You guys have that honor. And I want to, first of all, congratulate you on that and tell you that's kind of what you're doing today. Everything that you've seen has been training based. What I'll say is a lot of folks do this. They get their agents together for a morning or a day and they talk about training. But you guys do so much more than just get together for a day, especially this office, especially the Heritage office. And I'd be remiss if I didn't mention that. You put your money where your mouth is. Craig was the first broker to hire an in-house lawyer. And as far as I know, the only one in Texas that has an in-house lawyer. Now he's got 2. So, I want you, and Jack said, take advantage of that. I mean, that's why I wanted to say this. It is such an enormous tool that you guys have. I guess you have 2 tools. Take advantage of your 2 tools. No, I'm serious. you guys are really a unique company, Keller Williams as a whole, and then this Heritage office is a unique company as well, that will spend the time, money, and energy. So I just want to congratulate you.
Thank you, my mic's going out again. I guess they're just ready for me to get off the stage. Thank you so much. Aren't we the luckiest in the world to have this? Thank you, and next up.
Thank you, Judy. I think you're on non-negotiable.
Jack, you want this? Sure. I think I'm doing it.
Yes.
All right, everybody, give me 2 seconds. Can y'all hear me okay right there? Not at all. That's better? Oh, perfect. I'm not really technically savvy. All right, everybody, so these, they change slightly from year to year just based on new experiences we've had. They're the non-negotiables for Keller Williams Heritage. Every slide here has originated from a lawsuit. That's the rule of thumb to apply. That's why we do it. We don't just like making rules for the fun of it. These are things that I actually get questions on. If I don't get a question on every single one of these every day, I will probably start getting concerned. Because that means people are just doing it. So, I appreciate everybody reaching out on them. Let's go through them. It's not going to take just too terribly long. I think you all know these, but it never hurts to have a reminder. So, no KW Heritage Associate may represent themselves as a seller on any property whatsoever. It's not covered by E&O, and agents may not put personal properties in the MLS under their own name. You can't sell your own properties. The reason for that, you are so much more likely to get sued if you sell your own property. E&O doesn't even want our money. They don't want us to pay a premium on it because they're going to lose out. On top of that, even if you don't actually get sued, if you get a demand, even if you've done nothing wrong whatsoever, as a real estate professional selling your own property, if a claim is made, you've already lost. There's very, very rarely have I ever seen a jury that said, well, you know, even though they were a real estate professional and they knew more than the buyer and this and that, especially on flips, you've already lost as soon as it starts. There's nothing that limits you from saying, look, I'll sell your house, you sell my house, you can take a referral fee, you can do whatever it is that is necessary. You just can't be the listing agent. Now, a big and on the end of that is, and you cannot use a straw agent. So what we see oftentimes whenever a lawsuit or demand pops up is, well, I was selling my own house, but I got Garrett to be my listing agent. Well, I talked to the buyer's agent, they go, I don't know who Garrett is. I've never seen him, I've never talked to him. I have no idea who this person is. They were not involved start to finish. So what that means is that regardless of the fact that you used the listing agent, it's not going to matter because they were obviously just a stand-in. Any and all assumed names must be on record in every county you do business. They must be on file with the Director of Risk Management, who will then submit them to TRIC. So, if you're working under a DBA, group name, team name, anything other than a natural derivative of your name, we want to make sure we have that on file with TREC. We want to make sure the office knows about it. It's a $2,500 fine if they find out, if TREC gets wind of it. Normally what will happen is a TREC complaint gets filed for something unrelated, and then they can start looking at your business and say, hey, you're doing a lot of business under this name. It's not on file. This is a 10-minute issue to fix. Please reach out to us if you want to start using the name. Without exaggeration, Heritage probably has 300 DBAs on file. We want to make sure that we have all of these group names on file, all of your team names on file. In addition, the second point to that is it has to be on record with the county. Now, you can either set it up as an assumed name with the state, and that actually costs money because you do it through the Secretary of State, or you go to each county where you sell real estate. So if I sell in Kendall, Bear, Atascosa, and Medina, you need a DBA on file, Kendall, Bear, Atascosa, and Medina. Every KW Heritage Associate has signed an addendum to their independent contractor agreement agreeing to only work residential business. So if you are a residential agent, you do not have permission to sell commercial property from the brokerage, you cannot sell commercial property. The reason for that is as a residential agent selling commercial property, you're so much more likely to get sued. If you've never dealt with feasibility periods, environmental studies, anything that runs along with the commercial deal that you've really had not much experience with, or even if you've had experience on your personal end, you have no formal training for commercial, then E&O is not going to cover us. There is a way to start working on commercial, so I would invite everybody, if you want to start doing commercial work in addition to residential, please let us know. We want to be able to work with you. We don't want to limit anybody, but we also don't want you to get sued. Every KW Heritage agent must commit to reading the KWI Policy Guidelines Manual. Obviously, you've all done that. It's great reading. Everyone loves it. If you've never seen it, it's actually got some helpful stuff in it. I would recommend that everybody give it a peek because I'm sure it's sitting on your nightstand next to your bed for a little reading before you sleep. If for some reason you haven't read it, please let us know. We'll be happy to provide you with one. Do not use an intermediary form when working with KW CityView or Legacy. So, an intermediary form means that you're working within the same brokerage. So, buyer's agent, listing agent are both Heritage. Buyer's agent or listing agent are both CityView. It doesn't matter if you're both KW. Just like there are multiple RE/MAX offices, there are multiple KW offices. We are totally different franchises, totally different ownership, different companies. No intermediary form is necessary. Here's a handy-dandy little breakdown. So you have CityView with their offices, Heritage with our offices, and Legacy with their office. So if you're writing a contract within the red block, we need an intermediary. If it's within the blue or the black, we don't. What is an intermediary and what is the highest, lowest risk factors? So with an appointment, if a buyer's agent and a seller's agent are both, or listing agent are both within Heritage, but it's not within the same team or there's some separation, perfectly acceptable. You saw the market share earlier. 1 in 5 transactions goes through KW in San Antonio. We have a lot of intermediary. This is totally normal, perfectly acceptable. What's more challenging is whenever you have someone who's not representative. They have the acknowledgement of non-representation, and you represent the listing agent, and you have a buyer that comes in who doesn't have an agent. You are much more likely to get in trouble on that because whether or not you say you're giving them advice, they are going to feel like you're giving them advice. And more than likely, you are going to give them advice. As a rule, the less representation or the worse the agent is on the other side, the more you do. So if you have someone that comes in and says, look, I just wanted, you represent a buyer, you go talk to a FSBO, you do a one-time listing agreement, you go in, show them the property. Well, at that point, even though you're not representing them, or if you have a limited representation agreement, you're still on the hook because you will be giving them advice at some point. It's always better to try and bring another agent in on the deal. High risk is without appointments. So highest risk is if your team has the listing and a buyer on your team has the buyer, that is a very high risk situation. I walk into a lot of offices on larger teams and they're just yelling over their shoulder like, hey, we got that offer over here. Did you write that up? Oh yeah, I did. They'll take this, but and they'll start talking about it. It's a huge problem. So we want to make sure that that kind of stuff doesn't happen. You want to make sure that there's separation, especially if you're on the same team or you're a husband and wife team, there's clear separation, no emails, no commingling on that. Just make sure that make sure I have a defensible point, is what I'm asking. All listing associates must provide a written broker price opinion or CMA. So, you want to make sure they know what the property is worth. If you run the comps, you provide those comps, you say this is what it's worth. Because if it's not worth that, and there's a huge appraisal issue, and they think that you priced it wrong, or they think that you advised them incorrectly on putting in the offer, they're going to go after you for the earnest money. Happens every day. Because buyers and sellers take no responsibility for anything that they do. And it's always your fault. All the credit goes to them, all the bad stuff goes to you. It's just the way that it's going to work. That's why the CMA and the BPO are required. Transaction fees charged by agents and clients must have a standardized, justified explanation, and you cannot make money on them. So, if you pay your transaction coordinator $300 a transaction, you have the ability to charge your buyer or seller $300 a transaction. They can pay you at closing, and then at that point, you can then pay as a pass-through. What you're not able to do is charge your client $500 and then pay $300 to the transaction coordinator. It's a TREC rule, I'm not allowed to do it. Agents may not place an advertisement that implies that the agent is the person responsible for the operation of a real estate business. So, that's where the and associates, properties, realty, all of those modifiers in your name, that's where they come into play. Because once you use those, it's implying you're in charge. We've talked about it several times while we're up here today, and a couple different people, including Avis, who is the authority on the matter. Whenever you say, this is why we give the IABS, this is why we name ourselves the way we name ourselves, this is why we disclose and we put the things up that we need, that allows them to trace back and find out who's in charge. That's what Trek cares about. They want the consumer to be able to call whoever is ultimately in charge to complain about you. And usually that call goes to me, and then I call you. Agents may not use the terms realty properties and associates. That is a carryover from the last slide. Licensees' advertisements must clearly and conspicuously contain Keller Williams heritage, and it must be at least 50% the size of the largest contact information. So, if you have a big phone number on there, at least 50% that size. Don't hide KW Heritage in the corner. You know, we've had people that have wrapped their cards and then they put it on the back mud flap and kick mud on it because they don't want anybody to see it. You have huge brand recognition. Please take advantage of it. Even if you don't want to take advantage of it, it's a Trek rule. Any associate with an unlicensed assistant is responsible for ensuring the unlicensed person never acts as a salesperson. If you have an unlicensed assistant, they cannot act or give real estate advice. They're not allowed to facilitate a deal. They're really not even supposed to fill out paperwork. If you have an unlicensed assistant, they can answer the phone, they can do data entry, they can help you with back office. Realistically, they shouldn't even be talking to clients. All group team leaders must take the broker responsibility courses. Husband and wife teams are encouraged to attend, but are not required to. If you're going to build a team, you're going to build a group, we would all request that you do it the right way. I work with a lot more teams that fail than teams that succeed. A lot of the times, if you guys will come to us up front and say, look, this is what we're thinking about doing, if we can give you that checklist, including the broker responsibility course, your odds of success in growing your empire as a real estate professional go up dramatically. All group and team lead agents must have signed a group team hold harmless on file at the Market Center. So, we need an IC or an independent contractor agreement. If you're going to start a team, we need that agreement. We have to have it on file. I have a standard one. It's an email away. All we have to do is talk to me. The reason we want to do that as well is so we can put you in contact with a team lead, because there is a lot of misunderstanding on what a KW team is versus what a team is for Trek. Anyone can advertise themselves as a team for the most part, but it's different when you look at caps, when you look at how to best just like the MCA department, and then we do your advertising compliance. Make sure that you loop us in on that so we can take care of you up front. I really, really, really hate watching people waste money or invest time and money into something that ultimately would have worked had they done their homework up front. We take care of this for you, we help you, we have all the contracts done. Please don't hesitate to reach out to us. Under no conditions will a current licensed KW associate be permitted to join a group or a team. So, the reason for that is, as a caveat, lead agents cannot solicit from associates currently with Keller Williams. So, if you join KW as a solo agent, you can't then join as a team agent. If you're a lead agent, or, man, I really want to be buyer's agent, and I saw this person just killing it at Ignite, can't do it. You have to bring in somebody new or someone from an existing team by negotiation. Who's going to go steal people's people? But the reason for that is basically it comes down to profit share. When someone is recruited, you don't want to take their profit share away because that person joined as a solo agent. So please keep in mind the KW model is if you join as a solo, you're a solo. Any licensee who structures their business as a corporation, LLC, general partnership must have a broker's license to receive a commission. This is a Trek rule, it's not a KW rule. We can help you guys do it. Once you have a broker's license, we can help you get your entity set up so that you can then apply that broker's license to the entity, which allows us to pay that entity directly. Most people are trying to get the 15% self-employment tax knocked off. We can work with your CPAs. I encourage you guys to put us in contact with your CPAs so we can help you with that. I don't give tax advice, but I help a lot of CPAs make sure that you guys save as much money as possible on this. I don't want to talk to everybody's CPA. I probably can't help for the most part. All agents conducting property management other than their own personal investment properties without broker approval will be terminated immediately. So, that sounds really harsh. It is harsh. This is my rule because we are not covered by E&O for unlicensed property management. Please, 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 please let us know if you're managing properties other than your own. Even if you don't have broker approval, I need to know. You guys are hereby put on notice that we need to know. We can help you come into compliance, we can figure it out, we will figure something out to help you, but right now you are not covered by insurance. You're so much more likely to get sued for property management than you are traditional real estate, and it's something that you have no E&O coverage for. So please let us know. Are you leasing or are you managing? And Avis gave a really good example of this earlier on her panel. If you help somebody lease a property and you backed away from it, but then they say, you know what, we are in California, look, I know you helped me lease it, can you get a handyman out there? Can you do this for me? Can you help out? You're just trying to be a good agent. You're trying to help out your client. By helping out, you have stepped into a management role. So please be aware of that. There's nothing wrong with you sending them a list of people that you have approved for your vendors that they can then call on, but you don't want to do it yourself. Otherwise, you do become a manager. All escrow accounts being held by agents for property management must have a broker. That's going to change as a signatory. So, in order to manage property, you have to have a trust account with the broker's name on it. You don't know how to do that? You want to come talk to us? We'll make sure we take care of it. If you're managing property right now and you don't have a trust account with the broker's name on it, we need to talk today. Please shoot me an email so we need to straighten out. All property management files must be turned into the office within 5 days of execution with a 75 E&O fee. So, we still take the E&O fee because sometimes I can kick it into E&O. Most of the time we cannot. Sometimes I can make it seem like you're doing real estate services even though you're blatantly violating TREC rules and managing property. That's just what we do for a living. So, please, if you are managing a property, it's got to be turned in within 5 days so we can process it. Agents must never act as a power of attorney for any client. I get this, I don't know, at least a couple times a week. Clients going on vacation, they're going on a cruise, they ask if I can close for them. No. You can't execute a power of attorney. The reason for that is because you take on all of the liability. As a power of attorney, you are making decisions for them. If you had someone that said, well, you found out there was a leak the day before closing and you went ahead and closed, why didn't you talk to me? Well, you were on a cruise and they couldn't talk to you. Well, I wouldn't have closed. It's your fault. Now you need to fix it. That's a real example, and it is probably the most mundane example we have. These get really, really expensive. Always get a payoff amount from the mortgage company directly. So don't guess on payoff amounts. Unless it's from the mortgage company, I recommend you don't put anything in writing on payoff amounts, because if you get a payoff amount or you get a preliminary run sheet on what closing is going to cost, it's going to be wrong if there's a problem, I promise.
They will blame you.
Oh, absolutely.
They will always blame the agent
You
if
guys
you
provide
provide
it.
it.
And they're going to say, I needed to net 5,000. You told me I was going to net 5,000, and now I have to bring 2,000 to close.
Well, because the taxes were due, and the title company escrowed enough with the taxes, obviously to make sure they were paid in full for the whole year. But the previous lender is holding taxes in escrow, which will not be given back to the seller for an additional 3 to 4 weeks. And now they're really upset. Do you see that? You ever seen that happen before?
All the time.
I mean, it's happened to me. Believe me, I ended up giving up a full commission because I was not a fiduciary and it was negligent in getting all the details.
We had someone get hit the other day with 12 years of rollback taxes for the ag lien that they let go, and then someone else for an improper homestead because they have 2 homesteads filed. And title said, well, we're going to need $98,000 for the let you close.
Get a mortgage payoff and make sure the taxes are occurring. It's pretty simple. Jack, we're going to skip the chart compliance part since Avis already did the majority of it. But we're going to go right into the video and finish our last discussion for the day. Jack?
Right.
Jack Hawthorne, get it up.
Goins' daughter did that video. What'd you think about it? Pretty cool, right? Right? Okay, so we are here today to talk to you about KW San Antonio and some stuff that's a little bit more energetic than what you've been hearing for the last hour up here, hope. All right, so we're going to talk about some stuff that can help you bring some business to what you're currently doing. We're in March, April, and May. We're going to have a lot of buyers and sellers. Let me introduce you first to Kesley Smith. Everyone say hi to Kesley.
I'm the face behind all the emails you've been getting.
All right. So I don't have the slide to dance with me, Monica. So if you could advance the slides for me, I'd appreciate it. All right. So where's Penny? Penny Caramou. Stand up just for a second. Wave everybody when they stand up. Okay. So Penny came up with this great idea along with Stephanie that said paint the town red. All these open houses in New Braunfels that were last weekend. You came up with that idea. What a great idea. You should do it every month. So you're doing it again in April, right? So, next slide. We promoted this idea on social media. And what we did with this is we, if I can advance to that slide, what I'm looking for. We sent it out on KW New Braunfels Facebook and social media all over the city. We also put it on KW San Antonio. The beauty of this is we also promoted this on MySA. So guys, this website gets 4 million unique visitors a month. And trust me, we'd love to go with the Herald's iTunes, but they're not quite there yet. We're working with it. We're working with it. But they're not quite there. So MySA takes the listings that we give them and promotes them on their social media and on their website for the weekend. Take a look at this. Open houses, new listings, single family homes just listed, right there on the web page, on the home page for MySA. Now, Kesley's been doing this for about 6 months. Raise your hand if you've done this with Kesley. So about 20 people in the room have already done this. Did you have a good experience? Yes, you had a good experience. Great. It's a free service. It's a free service for your open houses and new listings to be promoted on MySA. So I know that there are a few of you that have done this, and this is actually a slide that's supposed to come next, I think. But I'm going to let Kesley talk a little bit in just a second about how this system works. So, Kesley, why don't you just explain to them how this works?
Okay, so like John said, MySA gets 4 million unique visitors a month. So what I do is I provide 20 spots for open houses and new listings in both their galleries for only Keller Williams agents. So every week I have a deadline of 4:30 p.m. on Wednesdays for that weekend. So if you have a new listing that you would like to submit, all you have to do is email me 2 photos of your property in high resolution, because you know how the MLS crunches down those beautiful pictures you take? We want the good ones, the high resolution photos. And then those will be submitted onto MySA. Just include in the email to me the MLS number, the address, and any like virtual tour link or anything like that. And the same goes for open houses. I want you to first use the agent portal on KW San Antonio to upload your open houses into Open House Connect so they can be on the front end of the website. And then do the same thing. Email me 2 photos of your property, the MLS number and the address with the day and time. And if you have another agent hosting it, tell me what agent is hosting the open house.
If Scott or Jeff is in the room, you know what we're talking about, because these 2 gentlemen had these 2 properties on MySA this weekend. In fact, that listing there in Bernie, Jeff, actually it's got a lot of listings around, got over 400 click-throughs last weekend, which is the top for the website. So it's pretty amazing that these listings are getting that kind of exposure. So not only does Kesley do that, but she also provides you feedback. Tell them about that, Kesley.
Okay, so every weekend it goes live on Friday on MySA. They upload the galleries Friday morning. So I go through to each single one and send you a direct link of your listing so you can promote it on social media, email it to the sellers, however you want to do it. And then on Monday, after I've had the whole weekend to see the impressions, I go on Google Analytics and track the impressions that it got from your single listing. I'll include, like in the email I sent to Jeff last week, I'll include the total impressions for the gallery and then for your specific listing. So like John said, he had a huge spike in click-throughs and it was awesome.
Okay, so I'm going to point out one thing to you. In the bottom left-hand corner of this slide is Kesley's phone number and email address. So that's who you'll need to get in contact with your open houses first, and then your new listings if you have new listings coming on. We really want to get you guys promoted out there. So as a tutorial, we have a nice little video for you. If you could just bear with us for a second. Monica's going to load that up. We'd like you to watch
the agent portal. Your login provides access to all the tools you'll need to market yourselves online to create a strong digital presence. In this video, we will show you how to use the Open House Connect system. Open House Connect is a great tool to showcase your open houses, as well as link you to realtors willing to host your open house. Let's get started. Log into your agent portal at the bottom of the KW San Antonio page. Scroll to Start Open House Connect and click on it. Click Create Open House Listing. Put in the MLS number without the pound sign, and it will auto-populate the listing information. To enter Open House, the listing must be entered by the listing agent. The only thing you need to put in yourself is the day and time of the open house you are entering. Right under the day and time field, make sure you mark whether you will be hosting the open house, yes, or will need another agent to host, no. If clicked no, your home will be forwarded to our Host Open House feature. Press Submit, and the open house will be entered. Once entered, the open house will appear on the website with a banner for viewers to see. Need help finding an agent to host your open house? We have provided you with a stress-free system. Link up with an agent you approve of to host your open house in just a few simple steps. Log into your agent portal at the bottom of the KW San Antonio page. Scroll to Start Open House Connect and click on it. Click Host Open House. A map view of San Antonio with all the open houses available to host will both provide you with the details of the open house and its exact location. Choose the open house you want to host, and it will bring you to the host invitation screen. The screen will ask you to invite a second or third host with you. This can be another realtor, a vendor, such as a home lending representative, husband or wife, etc. Once you have filled out the host information, press Send Invitations. An email will be sent to the listing agent, and once they approve you to host their open house, you will receive a confirmation email. Once you have received the confirmation email, get in contact with the listing agent to get the details about the listing. Thank you for learning about the exciting features inside the agent portal. We hope you take advantage of these tools to create a dynamic digital presence.
Okay, so the way we've been doing open houses before is through the internet, right? You send a little email out, you wait for like 3 or 4 days for somebody to get back with you, they want to host open house. As this system's available right now, that video is going to be posted in the agent portal and sent to you when we advertise every weekly for these open houses. So very, very simple to be able to do this system. So we go up to the next slide, please. Okay, so another thing I want to talk to you about is the Showing Agent program. It's going to be a very busy summer, and some of you actually want to go on vacation a little bit, or perhaps you just got 2 buyers in town at the same time. Did you know you have a Showing Agent program that you have access to where people have already agreed to what they're going to be paid, either 25% at closing, $25 an hour, or 10% at closing and 10% commission. All of those have been agreed to, and all you have to do is reach out to someone. If you have any questions on how to get in the Showing Agent program tool, ask me afterwards, or talk to Julie Forbes, who's the administrator at the Heritage office. Okay, and many of you already are. Here's a few pictures. Okay, so the last tool I'd like to tell you about is something that I'm pretty passionate about, and that is neighborhoods. We are starting on a neighborhood campaign. We're focusing on marketing a lot of neighborhoods across San Antonio. We're adding a new neighborhood page to the KW Braunfels page website. And as part of that, we want to make sure that people that are interested to come buy homes in San Antonio have access to a lot of information about neighborhoods. Have you guys seen the market conditions videos that are out there? Very powerful tool to let your buyers know every month what's going on in those neighborhoods. And you should be sharing that information on your social media, trying to attract buyers. So we also have a brand new tool we're just launching. It's the first neighborhood video. Guys, there's so much power in being able to tell somebody about what a neighborhood's like, especially if they don't live here. I'd like to just take just a few minutes and show you a really cool video on our first neighborhood video in Crown Ridge.
Unspoiled, I think is a beautiful word for it. It still feels like you're far out of the city. There's such a range of places to live. There's single family homes, of course, garden homes, condos, and then more traditional apartment homes. But those apartment homes are stunning. We have access in and out of this area, literally north, south, east, and west, without even getting on the freeway. In places like downtown, where you've got very urban things to do, we have all those things here. But what we also have is some of the best trail systems, restaurants, resorts, Six Flags, great golf course views. This land that you see with all the greenery isn't going to change. It's made for us to enjoy.
We feel like these 1-minute videos on the website are great tools for you guys to share with your buyers, your potential buyers, but also for people that are just looking to find a home in San Antonio. Would you agree?
Yes.
Yes, these would be powerful. We're going to do it in New Braunfels too. Thank you for your time today. Please catch us afterwards if you're interested in open houses or new listings on MySA. Thank you.
Give it up for them. They did a wonderful job. Thank you, Kelsey, John. Thank y'all. We're going to end it with a wonderful, I believe, technology tool that we are very excited to share with you. That I have my partner in crime up here, Kim Bridgeforth, will be sharing what she's been working on late at night over the last few weeks. To have available as a new resource and tool to every one of the Keller Williams Heritage agents. John's vision for creating an absolute stellar website for our company and each one of our business centers has been killer. The neighborhood videos, the neighborhood statistics, the SEO and juice we're getting out of it is wonderful. I can't wait to see what this website's going to do over the next few years. Doing so, we're going to incorporate also another part of our plan would be to have an app, an actual company app available to you to answer a lot of general questions and to help you, assist you without having to get on the website. Kim, one of the big things that I want to just make sure you've always asked me is, we said, what happens when we need resources and we tell them to go to the website, to the intranet? What happens when you were doing you were looking into this app? What was some of the questions that were coming forward?
Well, I think part of it, is this on? So I think part of it is I don't usually tell, and some of you know this, if you ask me for certain documents, to even go to the internet anymore. What I usually tell you is that Julie will send that to you. So maybe this is mostly just to help Julie out. But one of the things that we realized, there's so many resources now, there's so many tools, there's so many websites, both the KW ones and the ones that you guys are using for marketing, your real estate tools. Many of you are members of multiple boards, MLSs. Keeping all of that straight has turned into a full-time job. Do y'all feel that?
Yeah.
Passwords, usernames, different multiple sites. It's become very convoluted and almost, it's like being in a kitchen, in a chef's kitchen, a professional, commercial-grade kitchen with every available stove and pot and every available type of spices and meats and everything available, but where do you begin? Don't you feel that way at times? So all is available, but you just wanted macaroni and cheese. So what was the answer to some of this?
So we thought that the answer might be actually putting together a mobile app that starts to combine a lot of this information for you. So it's our very own Keller Williams Heritage, just for us mobile app. It should launch on Friday officially, so you guys are seeing a sneak peek of it. And so we're actually looking at it from the view of the dashboard where we create the app. And Monica, can we zoom in anywhere on that? Oh, yes, apparently we can.
So you can see the outline, well, barely, but they're on the screen back there. This looks like an iPhone. Don't worry about the left-hand portion from here over, because this is the administrative page, but what you're looking at is a live photo or live video feed of what it would look like on your mobile device.
So for instance, let's click on staff and see what happens. I know many of you try to look up the staff contacts. Some of them can be kind of difficult to find. Plus you're worried about if you're calling any Braunfels people, Seguin, or people back at Heritage. So what we've done here is we've put all of the staff together. And let's show an example. Let's click on Craig. Because what I want you to see is this. Rather than just having information at your fingertips, we wanted things that would be actionable. So if we click on Craig, what we'll actually get is some information about Craig. And if we click on the little red icon below his name,
Drinking wine. Who did that?
Julie. If we click on the icon, it will come up with some options. When we click email Craig, call the office, text Craig, or call Craig's cell phone, it'll actually come up on your phone where it just starts dialing the number. Or it'll pull up the text message screen. It'll pull up the email screen. And it will do that for all of the staff that we have available to you, plus their pictures. I know some of us, we speak to each other on the phone and never quite get that face to the name for weeks or months later. So we hope that this is a value.
So it actually, when you push call office, it clicks right to your phone, and it's calling the office, or calling my cell phone, or calling, or emailing right from here. Do you see that as a huge device? Sometimes I see somebody who tries to say, well, who do I need to talk to? Who do I need to call? Where do I get a hold of them? Wouldn't it have just one nice place to have all the information available instead of going to multiple sites and looking it up, or having to call a main number? And then you say, well, no one returned my phone call. We're trying to eliminate that. We're trying to eliminate the confusion or the additional bridges you have to cross.
So let's back out of this and go back home and look at training. One of the things that we did is incorporated and actually provided a feed from the kw.com calendar to download all of these calendar items straight into the app. And one of the things you can do when you actually open any of the events under training, it gives you the button right then and there to add it to your personal calendar. So instead of having to go look something up, pull up your own calendar, make sure that you remember that date, we have so much training going on all the time. This will actually put items that you're interested in straight into your phone so that you remember on your schedule when and where they are.
Will it have the New Braunfels calendar?
Everything that goes into the KW intranet is being fed in. So as long as we put those events into the intranet, which I believe we do, if not, we can definitely start. It'll show all the New Braunfels ones as well.
Kim, what's really nice about it when you set the profile of it on day one of the app is it asks you what distribution groups you want to be a part of. So what's really nice is it gives you a lot more options than what we're showing you. But yes, it will be very, the opportunity here is to make the profile searching based on the user, not what we want to give you, but what you're looking for.
So let's look at the links back on the homepage. So if we go into links, one of the things that we put together was a list of links that I get asked for frequently. This is everything from CSS to the different boards, to MLSs, to contract hotline, some of the different vendors that we're involved in. We are still adding information to this. And it's actually,
these are just a few. And as we get more collective information from you, we will be able to add them to the links as well to make it more user-friendly.
so we've added in, for instance, Seller Shield, some things that we talked about today, TAR, track zip forms. I know we mentioned zip forms now has all of our forms in addition to Connect MLS, in addition to .loop. The idea being that whichever one you're most comfortable using and have been using, all the forms are available to you. So we wanted to make sure we have the links to those on here as well. So let's look at the next feature. If we go back, and we can go to, let's go to legal, and I'll just tell you, we did make a list of all of the locations and their phone numbers along with maps so that it'll pull it up and give you directions to the different KW offices. And under the Facebook, which we won't take a look at, we actually added links to all of the Facebook pages. New Braunfels has a Facebook page, Seguin has one, Lake McQueen has one, Hill Country has one, Heritage has 8, AHA has one, Hearts and Hands has one, KW San Antonio has one, and KW New Braunfels, down through John Ullman, actually has a second one. So we put all these Facebooks in there. And part of that is because some of the content that John is putting out on the KW San Antonio and the KW New Braunfels pages, that is pure gold for you guys to repost that information. So we wanted to make it really accessible for you. So let's look at legal. And this is another thing. We started to put together the most commonly asked for forms. And some of these, I think I pulled off zip forms, Craig pulled them off zip forms. Some of them I got on the intranet. Some of them I had to email staff for. So I really got an idea of what it's like for you guys
Open one up.
to try to put these together. And we'll see if it opens in the window. No, it's just going to give us a preview. Let's go back.
On your your screen, I did it yesterday, and it worked beautifully. It downloads the entire forms right on my phone, and I'm able to either text it out as a PDF, email it, or use it right from the screen. It was absolutely amazing, the power of no longer now saying, where is that agency non-disclosure form, Craig? I know I'm on the road right now. I need the form, and I know you're not at the office, but I need it right now. How do I get it? What am I going to tell you right now? Go to the app, push one button, legal, and it opens a form for you. Isn't that amazing? And and these will be added on as we go along. As we get better and better.
How many of you use Google Docs or Google Drive? You are going to love it because that's how we hosted all these. So as soon as you open them up and they're actually in the phone, you can click the download button right away and it saves it straight to your Google Drive. So you'll have on your Google Drive in the future. And then of course you can edit it, fill out the fields and everything else in these PDFs straight from your Google Drive and then save that straight to your phone so that you'll always have it.
Go back to the main line too after legal. Did you go through enough on that? Even the W-9, we put one of the requests we always get is a W-9.
Yeah.
And you're always like, well, where is it? Well, go to the app. So, or you need a seller shield information, or you want to refer. How many of you have asked me, I need a referral agreement, I don't know where to find it. It's like going to the commercial kitchen and you don't even know where to look because the kitchen's so big. So now we have one app, one store, one location. As you see that scrolling, that's going to be on your app at the very front. If you were to push Hank's little face right there, guess what happens? It calls him. And guess what? He answers. And we're also going to have one for Garrett as well, but it'll go straight to either office or email because he doesn't use his phone because he's always in the office. But we want to make this we want to give you the experience of being with our company to where even though you're one of hundreds of great realtors, but you're still treated as if it's an absolute Starbucks experience. If you ever go to Starbucks, I ever go to Starbucks anywhere I go across the country, the experience is the same. Would you agree? Usually. Why do people buy iPhones? Why are they buying Apple? Because they trust the product. They trust who's providing it. We want to get to the level where you trust when you go to this app and you open it up. There's a lot of things we can offer you without having to go to additional resources or tools that Kim has come up with to where it's a one-stop shop.
So let's take it straight back to the homepage. And we did. We pulled up the acknowledgement. I think slated to go in this afternoon is that form where if you're not going to put it on the market right away in the MLS. The form whose name I don't remember because no one ever remembers it. So we'll put that in there as well. Does anyone know what that form is? Did all the lawyers leave? Okay, then I'll stand up here still. All right. We do have a chat feature. And also, the little heart icon is a feedback feature. And I really want to point this out because we're going to launch this week through the iPhone store. It's actually available in the iPhone store. We're waiting for one more update to get pushed to the store. It's actually been submitted to the store. We're just waiting for the store to push it out, which we can't control, but it should be done by Friday. And when it does hit, I'm considering this a beta test. Obviously, we're showing this very early. I don't have a video and I don't have slick screenshots yet, but as Craig and I were talking, he thought it was so important that you guys understood that this was right down the pipeline. That it was something that was coming out before the summer hit that would make your lives hopefully a little bit easier. So this feedback button, what it lets you do is you can actually go in and you can leave us feedback as many times as you want. So anytime you're using the app and you think that it's missing a person, a form, a link, anything that you think would make it better or make it something that would make it more useful to you every single day, multiple times a day, I definitely want to hear about it. So please leave us as much feedback as you want. I live on feedback and I love it.
Are you going to put all the agents on there? That would be amazing.
So I'll tell you a couple things we have in mind for the future. One is we'd like to do a true tech support desk through the app so that you would actually be able to go in, click on what your question is. If there's an easy answer, have it pop up for you. And if not, give you options for making appointments, either with Dave, Monica, Caitlin, Chandler, and also be able to be smart enough to tell you which of those you need to be speaking to, right? As our staff has grown bigger to provide more support to you, figuring out which of us you need to speak to, I know is sometimes a thing. I don't always know which of the tech people to ask. So we want to incorporate that. And at some point, we will probably look at trying to merge this with the KW San Antonio backend. We're gonna have to talk to developers and see about the feasibility of that. That would definitely be a long-term goal that we absolutely want to look into. And that would give us all the agents.
Last questions? Yes?
Android, still working?
Android as well. Android, hopefully any of your, except your flip phone. Yeah, I know a few of you out there, mine right now have it still. That or the brick. Who's got, who remembers the brick? Who was in real estate when the brick was there? Come on, raise your hand. Who's in the back over there? Pat, I see Patty. I can't see, who's behind there? Esther, oh, there's a few, okay. The brick was a famous phone, but it will not work in this app.
What's it gonna be called exactly?
Mine, AWH. We thought we'd keep it simple.
And what's really nice is I downloaded it last night, and I'm really, if I can make it crash, it happens. And she was really impressed that I couldn't make it crash. So it looks like it's going to make it. We're hoping to have this out by Friday. We'll be sending an email out to every one of y'all. We want you to go to the store and download it. The locations is great. There's a lot more features on it than we're going to be able to show you. But what do you think? I want to give it up to Kim Virtual for putting this together.
I want to add one more thing. Some of you may have noticed, and I know some of you mentioned it to me, mandatory meeting went paperless this year. There was no stack of 30 pages for you guys to throw away next to the donuts on your way out, next to the kolaches. So the intent is actually to use the app and have an icon up there on Thursday. You'll be able to download the PowerPoint presentation, plus the market share slides, and have links to some of the different tools and videos that we showed today. That'll be straight into the app, so you guys will have all that information, again, at your fingertips, not 13 clicks away on the internet.
You don't have to go to the internet anymore. That's what we're hoping to do.
That's
Folks, we're going to finish it off. Stephanie, you would like to mention some leadership here.
Yes, thank you. We did not mean to go over that slide so briefly and abruptly. We're going to get you out of here 5 minutes over 1 o'clock. I do want to recognize our Agent Leadership Council, who truly, truly has your guys' hearts and minds and business in their thoughts when they make decisions. They give up so much of their time. They want to make this office so cultured and wonderful, and they do a great job at that, and I would have nothing without that. So,
why don't you have them stand up? ALC, would you stand up, please, if you're here?
Please.
And the ALC.
Pam Smart, Valerie Tolbert, Jim Chappelle, as they say, Jim Chappell, Kathy Blanchard, Jan Boyle, Marcia Kovar, Suzanne Kutz, Daryl Kubenka, and Lori Jarrett. Thank you guys so much.
Well, we promised we'd get you out of here by 2 o'clock, so the remaining next hour, y'all can hang out and
we're going to do more icebreakers.
Sing and dance. Folks, we promised you 1 o'clock. We made it. Thank you for being here, and thank you for just being with the company. We love you. Bye.